Lawyers, has there ever been a time the opposing counsel accidentally proved your case for you? And what happened? Story 1, I had a hearing where the opposing party offered an updated contract that my client supposedly signed. Except it was a horrible copy and barely readable. Then he assured the judge that the new contract was exactly the same as the old contract, except for the party name at the top. The original contract was in his mom's name, the new one in his name, and the date of the contract itself. He made that assurance multiple times. After he exhausted himself saying how everything was the same, I then pointed out to the judge that half the provisions were different and that my client had never signed that form. The judge asked if we were really accusing him of forging my client's signature, since that's a serious accusation. I held up the guy's prior conviction for contract fraud and said, "I absolutely am, Your Honor. We won. Hands down. No further argument needed." Story 2. My dad's ex-girlfriend took us to court over his estate after he kicked her out. Her claim was that she was entitled to half the pie due to de facto marriage. Our claim was that she was a gold-digging who planned it from the beginning. She had mountains of evidence of her contribution to Dad's company and running the private estate. Expense reports, receipts, dates, and times. Times her and Dad proved their relationship with trips and combined spending, etc., etc. She had so much evidence the judge took 4 days to look it all over, after which he came back and basically said, "Why the would you have all of this if this wasn't your plan the whole time?" The case was very downhill from there. Edit Jesus Christ Weepin' Bell. Okay, some more clarification. 1. She'd done the same thing to her ex-husband, giving precedent. He and her children said so in their testimonies. One of her children even inadvertently admitted she'd told them what to say and paid them for it. 2. We were able to name the date the relationship between her and my dad ended, which was months before she claimed, and outside the time limit to make it a de facto common law marriage. 3. We had testimony from the doctor at his ICU who said she tried to keep everyone, including his ex-wife, our mother, and us, his children, away from him. Meanwhile, she had his phone and computer and was trying to take over his contacts and business. We had proof of this. 4. Her lawyer was a moron who constantly contradicted himself and the evidence. He lost documents, gave incorrect dates, and asked irrelevant questions of the defense. 5. In the end, it was that her expenses for the relationship were deemed normal for anyone in any kind of romantic relationship, that gifts and meals aren't claimable for compensation, that her contributions to the household and business were not sufficient to warrant compensation. She never actually put any money into either, and that the relationship was not sufficient in duration to qualify as a common law marriage. 6. This case took 4 years to settle, including 2 elevations of appeals. She finally gave up because she'd run into about $250,000 of court fee debt, as well as being forced to pay us $40,000. Story 3, I had a misdemeanor possession case I was defending. Client was driving his mom's car. He gets pulled over for playing the stereo too loud. There are pills in the center console, in a prescription pill bottle. The bottle has his mom's name on it. Client gets arrested and charged with possession of a controlled substance without a prescription. Case is obviously bullshit, but the dumbest DA I've ever met in my life won't dismiss. We go to trial. During closing arguments, the DA says, "This case is a circumstantial evidence case." During my closing, I slap the jury instruction on the projector that says, if a case is based on circumstantial evidence, and there is one factual scenario that points to guilt and one that points to innocence, the jury must find in favor of the defendant and acquit. My client was acquitted. Edit RIP my inbox. Also, there are some amazing discussions below. That makes me really happy. I responded to as many questions as I had time for. DM me if you have a legal question about this case. Lots of you were interested, so the jury instruction is Calcrim 224 if you want to look it up. Story 4. Not a lawyer, but was taken to court once. A guy had taken my family to court, basically he had been dating my mother, and things ended. So he then takes us to small claims court with an itemized list of everything he'd ever bought the entire family. Every cheeseburger, every Kit Kat. He even billed for things he did, like house repairs. Some of the repairs were terrible and ruined other things. He tried to unclog the sink and ended up destroying the main drain pipe for the house. Now he had bought some more expensive things as well. No one asked him to, but he was one of the types that loved to show how much money he had and would always talk about his connections and would name drop someone anytime we went anywhere. So when he takes us to court with his full itemized list, the judge asks him to go first and present his testimony. He basically says, while I was with them, I bought all this stuff. I took them to dinner all the time and all this, but it was the idea it would be paid back by them. Judge, you bought a child a birthday cake with the idea it would be paid back? Did you ever say that these things were loans and not gifts? Him. Well, no. But I shouldn't need to. That's the normal way people think, Judge. Well, that's not the way I'd think. Case dismissed. Story 5. Not a lawyer, but took my BIL's landlord to small claims court. He's on SSI and I'm his conservator. We sued her for over $4,000 after she just decided she didn't like him and changed the locks on his apartment door. She also stuffed all of his belongings into trash bags and dragged them out to the curb. This was all done the day after she cashed his rent check. It all started because she was letting herself into his apartment with no notice and was going through his stuff while he was gone. When I found out about this, I told him to let her know that was not okay. He did, and that's why she kicked him out. I'm very organized and presented the judge with a folder containing photos, receipts, short videos on DVD, and the sheriff call logs, as well as a concise timeline of events. The landlord showed up with her son and countersued for the exact same amount we were suing them for. Claiming that the apartment was trashed, there were holes in the walls and they would have to repair everything before being able to rent again. During the hearing, the judge asked for evidence of the damage to the room. The son whipped out his cell phone and showed a video panning and walking around the room. The video showed my BIL's apartment obviously still being lived in. His stuff was all still there and no visible damage, but there were a lot of posters and things hung on the walls. When the judge looked at the video, he asked, "Where is the damage?" The son replied, "You can't see it. It's behind all of the posters." The judge frowned and looked at the video again, and then said, "Did you take this video when he was still living there at this time?" The son replied, "Yes." This was the clincher. The judge then asked, "Did you ask his permission to enter the apartment to take this video?" Silence. We were awarded the full amount. Story 6. I had to go to court over a financial up when I was a student. Took advice from the university legal support team who said I didn't need a solicitor, so I went in alone. The judge didn't like this and postponed it for another date, so I could prove I'd had more counsel first. The other party's solicitor caught me outside the court and said, "I didn't tell you this, but," and pointed out a huge error in the financial paperwork that made it very obviously come out in my favor. Went back to legal support, got confirmation that it was right, went to the second hearing alone, and got the entire thing thrown out. The other solicitor winked at me as he left. Saved me about $9,000. Nice chap. Story 7. Not a lawyer, but a relative of a retired prosecutor. Relative was working misdemeanor criminal court. Cases get called in alphabetical order, and two women named Catherine Smith and Catherine Smith were scheduled to have their hearings before the judge. Not their actual names, but you get the point. Both had similar crimes, but slightly different. So the bailiff announces the next case to the courtroom, Catherine Smith, for 1 count of possession of cocaine with the intention to sell and 1 count of prostitution. So Catherine Smith stands up and indignantly cries, "Whoa, whoa, just wait a second. Where did the prostitution charge come from? I may deal crack, but I am not the easiest drug dealing case my relative ever prosecuted." Story 8. Actual lawyer here. From the Fool for a Client file was interning at Legal Services after 1L, doing discovery work for family law. My supervisor invited us to observe a hearing for our client to get a restraining order against her husband. At the hearing, the client discussed various times he threatened her. The man, representing himself, interrupted and said, "Judge, I never said any of those things. If I had, she wouldn't be standing here. Restraining order granted." Story 9. Not a lawyer, but here's a story from the burbs. My buddy is in the middle of a situation like that right now. His psycho neighbor built a wall too high and doesn't have proper drainage on his property for the very small creek natural drainage in between their yards. My buddy hired an attorney as the psycho decided to sue him over it. My buddy's engineer that looked over the property noted not only did my buddy set his yard up right, but the neighbor created drainage problems. Neighbor hired his own engineer. That proved my buddy was correct. Now the guy is likely to go postal. Case was going to go to mediation. Since both engineers found fault with the psycho neighbor, my buddy decided he's going to take it to trial. Turned the tables a bit. We'll post a follow-up if I can find this thread after the trial wraps. Story 10. My favorite is a story from Jerry Spence. For those who don't know, he is a famous trial attorney. A witness on the stand was claiming that he had suffered injuries to his arm because of a city bus accident. Jerry asked him to demonstrate to the jury how far he can lift up his arm after the accident. The witness makes a feeble effort of lifting his arm. Then Jerry asks the witness to demonstrate to the jury how far he could lift up his arm before the accident. He lifts his arm much higher. The jury laughs. The case is over. Edit spelling. Story 11. I am not a lawyer, but witnessed a pathologist win a case in court by destroying the defense's credibility. The question was over whether or not carbon monoxide poisoning could have caused certain signs of death in an individual, but the defense didn't study their chemistry very well and kept asking the pathologist whether carbon dioxide could have caused these signs. After thoroughly frustrating the defense by answering his questions incorrectly, the pathologist said very loudly, "Oh, I'm sorry. Did you mean carbon monoxide? Because that's a completely different thing." Completely destroyed the defense's credibility in front of the jury. They were done after that, so I guess the opposing counsel screwed himself by not picking up a book. Edit. For clarification, this is not the only reason that lawyer didn't win. There were a lot of other things that didn't work out in his favor, but those were technical things that he probably knew about ahead of time. This was a case where he was asking a question that he thought was going to work out in his favor, but it worked against him because he made a basic chemistry mistake that he honestly should have caught. Yeah, I know, he's not a scientist, but you don't have to be a scientist to remember the difference between those two things. Getting terminology correct is part of his job. It's not like anyone caught a felony charge solely because he said that one thing wrong. Story 12. I worked as an intern for a lawyer. Construction law in France are quite strict in regard to the neighboring of historical monuments. The city was denying a permit for heavy modification of the house of our clients. They were arguing that because you could see the house from the church's bell tower, modifications were impossible. As a support, they kindly linked us to a 360 picture from said bell tower. We, as kindly, pointed to them that our client's house was, indeed, not visible from the top of the church. Building permit was greenlit the following day. Story 13. Actual lawyer here, and this one was especially sweet, was involved in an ownership control dispute of a Venezuelan company. While we had no doubt who controlled the company, opposing counsel had created enough smoke to create just enough doubt for our federal judge to order us to file a declaratory action. After a few months, we received the equivalent of a declaratory order from the high courts in Venezuela, basically saying our client was in control of the company. We had the order translated and certified and drafted a motion explaining to the court how these orders from Venezuela work and how they are in effect the highest law of the land, which meant the case should be over and our client was in control. Opposing counsel drafted an almost identical motion, but they had not received a copy of the newest order. In other words, opposing counsel agreed with our position that these orders from Venezuela would definitively prove who controlled the company, but attached the older order. We prevailed in the declaratory action, and the judge referenced the fact both sides had the same argument in the final order. Edited for spelling prepping for Irma has left me unable to spell and to add the following, some background. The original Venezuelan High Court order. First order created the equivalent of a receivership in the company we were representing. The receivership hired us to pursue an unrelated claim here in the States against an American company. The receivership was put in place by the shareholders and the Venezuelan government as the owner of the Venezuelan company Douchebag was embezzling money and running the company into the ground. There was another firm representing the company before we were hired, and they decided to ignore the first order and claim to the federal court here in Miami that they were the only ones representing the company and that we were the imposters. They argued that the first order was not valid and Douchebag was still in control of the company. There was a second order, was the result of an appeal in Venezuela that was very ambiguous in its language and cast some doubt as to the control of the company. Douchebag and his attorneys submitted the first and second order as support to their motion. A third order was issued by a different Venezuelan appeals court, which put the issue to rest. We asked for and received a copy of it. They did not either because they knew it was not supportive of their position, or because they dropped the ball. We believed it to be the latter. Our motions cited similar case law and advanced the same positions, but were interpreting different orders. TLDR. We did our homework, they didn't. Bonus TLDR, Venezuelan courts are. Story 14. A guy I used to work with was going through a messy divorce about 20 years ago now. His soon-to-be ex-wife was a psycho and her father was a psychologist, so he was pulling all of the strings. Even had my coworker arrested at work one day, BS charges. The divorce case took years, one young son involved, and at every turn, my friend lost because of something the father filed or another string he pulled. In the end, they were in court, and it was very apparent that my friend was going to lose custody and all visitation rights. Every plea he entered was squashed, and he was mentally broken. The judge asked the ex-wife if she had anything else to add, and she said she had a written statement that she wanted the judge to read. The bailiff took the paper from her and handed it to the judge, who unfolded the note and read it. He stopped for a minute and asked her if she was certain she wanted this note added to the case, and she said yes. The judge turned to my friend and said, paraphrasing Mr. X, all these years and all these claims that I ruled against you. The court profusely apologizes. I did not believe you, but now I do. Ruling in your favor, bangs the gavel, I grant you full legal and physical custody of your minor child. Bailiff, please handcuff Miss Cax. My buddy was stunned that he won, and happy at the same time. He later found out that the note said, give me my son or I'll kill you. Story 15. Obligatory IANAL, but I am a certified paralegal. I went to court and spoke for a friend at a hearing. I can ask questions to both parties and address the judge. The only thing I can't do is object to the other lawyer's line of questioning. So here's what happened. Best male friend was fighting a restraining order against him by his crazy ex-GF. Everyone was in the courtroom that day, including her. Her lawyer questioned Mai about their relationship. As an aside, they lived together. He moved out and got his own place, but they were still together. She just got obsessively crazier to the point where they broke up. She wanted some stuff back that she gifted him, and he refused to let her in while not home to get it. She got crazy angry and made a scene in his front yard, getting cops called and the neighbor's dog taken for being a pit bull in a park where they were not allowed. Bullshit, I know. Next thing you know, she's got a restraining order on his mom who lived right next door to her son and is trying to get one on him and sue him for his back. So when he's on the stand, I'm questioning him about the incident about her showing up and trying to break in. His mother called him the moment she saw her banging on the door, so he beat the police there. She had gotten in and was in the living room. I asked him if he was in fear of her, and he says absolutely, because upon waking in, she slid an iron bar from her sweatshirt sleeve, telling him to back off. He was just standing there, mouth open wide and shocked. Cue her turn on the stand. I asked her about the day, if she had gotten in. She insisted she did via a key, which we knew was a lie. She never had a key. So then I asked her about the iron bar. Why did you have it? Where did it come from? My cop friend gave it to me to protect myself while driving from road rage. It's in my car all the time, so I just brought it with me in case anyone was inside that wanted to mess with me. And did you have it up your sleeve? Yeah, 'cause I didn't want neighbors to think I was breaking stuff. She was bawling and slamming her fists into her thighs and pulling her own hair, wailing. I rested after that. She admitted to trespassing while carrying a concealed weapon. Both restraining orders rescinded. She was asked to stay after court was adjourned, and the judge handed her mandatory therapy and committed her for observation. Shauna, edit major thanks to you, dear occupant. He's helped with the law for all if your suspicious idiocy's a lawyer, I know. But my parents were in a lawsuit where this happened. They owned a business, and on the either side of it were businesses as well. Their neighbor to the left sued us, claiming that we had been using their property without paying them or without permission. That we were essentially trying to adverse possess it. We got a surveyor to come in, and the surveyor said that not only were we using all of our property, but we had been paying rent to them on about 20 feet that was also our property. Obviously, they weren't happy, so they got their own surveyor, who gave us 50 feet. We won the lawsuit. Now their little patch of property has a rusty fence all around it with keep out signs everywhere. It's about 20 by 10 feet. Story 16. When I first started, my firm had me on a case where the client claimed he lost because of ineffective assistance of counsel, basically saying that the old lawyer didn't do his job. So we prepare an argument based on not asking the right questions, not communicating, etc. We think it's going to be a tough case, but not unwinnable. Then we get the response to our complaint, where the old lawyer argues that he was only ineffective because he didn't have time to prepare for the case and only reviewed it the morning of the original trial. He had known about the case for months, by the way. The judge saw this, and during the trial we had essentially asked, isn't this the definition of ineffective counsel? Not giving enough time to your client? The silence from his side of the court was amazing. Needless to say, the trial didn't last much longer than that. Thanks, opposing counsel. I guess you were ineffective for both of you. Story 17. Not a lawyer, but in a suit against an employee, her attorney presented our contract and their contract to demonstrate the differences to prove that his client hadn't stolen ours. Then where did you get our contract? Dumb asses. We won. Spent a couple $100,000. Defendants both ordered to pay $10,000, filed bankruptcy, and dissolved business. Started anew with another competitor. Life. Story 18. Am a lawyer, but this was from my time as a law clerk. Tattoo artist, around 40, gets charged with rape of an employee. The victim is 17, very fragile, and barely able to sit in the same room as the defendant. She stares at the table the entire time, and you are barely able to hear her speak. She does not elaborate much on details, but basically he forced himself on her after closing the shop for the day. The defendant's story is that the employee came onto him and that there was consensual. The defense calls a witness, another employee at the same shop, to basically tell everyone what a stand-up guy the defendant was. If I were to guess, I think the court were undecided, but maybe leaning on a not guilty verdict up until this point. The defense witness takes the stand, starts telling a story of how the defendant, while doing a tattoo on her, tried to hold her down and kiss her, but had to stop because someone else came into the shop. Game over. Perp got convicted of rape. A week later, he declared that he was satisfied with the penalty and chose not to appeal. Edit. Just to clarify, since many comments are based on US law, this happened in Sweden. Story 19. Not a lawyer, but I am a former insurance fraud investigator. We were at a hearing before the WCB. I had something like 18 hours of video spread over a 2-week period of a claimant doing roofing work. The problem, for me, was that the video didn't get a clear face shot. Normally, what we like to do was get in close, show the face for a positive identification, and then zoom out. Bonus if the claimant was wearing distinctive clothing that could easily be tied to him. Because of where this guy lived, all I could do was show someone who matched his description, getting out of a truck registered to him every morning. He wore a hat, he had a beard, and he had neither at the hearing. So the company lawyer is prepping me and basically letting me know to be on point, because the claimant's attorney is almost certainly going to challenge the fact that it is his client in the video. If the video got tossed, the case was lost. About 2 minutes into the hearing, claimant's attorney agrees to stipulate to the fact that it is his client in all of the video. All of it. Our attorney was shocked. That was pretty much the only leg he had to stand on. Claimant attorney was incredibly smug right after this, like it was no big deal. Evidently, his strategy was to show that his client wasn't really a professional roofer, since he was doing the roof the wrong way. He tried to get me to answer questions about roofing. I refused, as it was beyond the scope of my work. And he just wouldn't let it go. After about an hour of back and forth over this, the judge finally said, "Counselor, it doesn't matter if your client is doing the work well. What matters is that he has stated numerous times and under oath that he cannot work. Whether he's doing it for free, for cash, or for fun has no bearing on the fact that he's doing a roofing work while collecting compensation benefits which he was awarded because he couldn't do roofing work." The guy lost and had to repay a bunch of benefits. After a few of those hearings, I began formulating a list of lawyers I would never hire and ones I would absolutely want on my side. Story 20. IAAL. Sued a trucking company for underpayment of wages. They claimed they paid by route and not by the hour, despite doing their payroll by the hour, because they had a USPS subcontract that supposedly told them to pay by the route. Defense calls the owner of the business to the stand and questions her about the contract, which is clearly incomplete. She explains that the company gets a new subcontract every 4 years, without fail. On cross, I flipped to the first page of the contract and read the date, which is in the spring of 2011. Q, did I read that correctly? A, yes. Q, and you get a new contract every 4 years? A, yes. Q, so you got a new one around the same time in 2015? A, yes. Q, and why you haven't produced that contract today? A, I haven't seen it in years, but it's the same thing. Q, where does this contract tell you to pay your drivers by the route? When she can't answer, I follow up with, and the 2015 contract that we don't have says the same thing? My client started working for them at the end of 2015. Their whole argument was based on a contract they couldn't find. We won. Story 21. Ooh, I've got one. I was about 5 when this happened, but my parents explained it years later. There were a series of trees on the sidewalk in front of each house on the street. Although they were not part of our yard, the tree was owned by my parents and they were responsible for it. Some guy tripped over a branch and was seriously injured. He came after my parents for all of the money. The dude showed up with a mountain of evidence: hospital bills, psychologist testimonials, a photo montage of his slow and painful recovery, etc. Apparently, his lawyer brandished this stuff like a bat before court. My parents' lawyer thought he had a good case, until the first day of court, when he walked over with a picture and asked, "Is this your tree?" My parents looked at the photo in disbelief. "No, that's actually not our tree." The opposing counsel repeated the question. It went back and forth a few times until my parents' lawyer incredulously produced a picture of their tree, which was, even to the untrained eye, a completely different tree. At that point, the opposing counsel whirled around and started screaming at his client, "You said that was their tree!" Case summarily dismissed. My parents walked out in shock, came home, and bought me ice cream. All's well that ends well. Edit IANAL, obviously, but neither are most of these commenters, so I thought it was all right. Story 22, IAAL. Not my case, but I was in the courtroom watching a trial. Pro se defendant who was accused of flashing a guard and masturbating till, well, you know. As a pro se defendant, he defended himself at trial without an attorney. Prosecutor was doing well proving the case. When the female deputy was on the stand, the defendant asked her one question. "If you saw me do what you claim I did, then how big is my—" The deputy responded by raising her hands and estimated about 15 inches. The guy grinned, turned to the jury, nodded, said, "Yeah, that's right," and sat down. Obviously, he was convicted. He was doing a 10-year prison sentence, so this conviction wasn't of much consequence, but he'll never forget it. Edit clarification, re-proceed. Story 23. Accidentally proved? Not often. Made tactical errors? Often. Arguing a case on a voter recount in front of a judge. Judge says, "I'm going with X." That's in my favor, so I shut up. Opposing counsel, in arguing a different point later, suddenly goes back to the earlier point and belabors it. Client also, a lawyer says to me, "Don't say anything." I whisper back, "Don't worry, wasn't planning to." Judge begins rubbing his nose and looking irritated. After a few minutes, cuts off opposing counsel, saying I already ruled on this point. "Mr. Smithme, anything to add?" I replied in the negative and won my motion. Would it have come out differently? I don't know. Did opposing counsel make it easier for me? Absolutely. Story 24. My opposing counsel made some off-the-cuff remarks about how their client had to go to another remote office to get all the records they wanted to use against my client. That let me know the witness they were trying to use to introduce the records as evidence wasn't actually familiar with the records or the records-keeping process. In the jurisdiction we were in, records were exception to hearsay rule, but you needed someone familiar with the creation and maintenance of the records to get them admitted. I attacked the witness qualifications to get the records admitted and ended up getting the records excluded. I then made a motion for a directed verdict on the grounds they couldn't prove the case without the records and won. All because the opposing counsel complained that their witnesses had to go way out of their way to get records for the court. Story 25. Domestic violence case where the husband beat the wife senseless. Landlord tried to evict wife for breach of lease due to the beating. Landlord claimed wife violated lease terms by allowing police to be called to property and causing a disruption. My argument was that as a domestic violence victim, wife is covered under VAWA and the property is HUD subsidized. Also, MD law offers DV protections too. Landlord's counsel during his opening talked about how my client was beaten and the police were called and an ambulance, etc. I just stood there looking at him. When he finished, judge asked if I had anything to say. My response, "No, Your Honor, I believe opposing counsel has said everything that needs to be said." Judge smiled and ruled in my client's favor. Landlord can't evict DV victim. Story 26. My public defender wife, not a Redditor or I'd get her to speak for herself, was trying a case where the defendant was accused of filling fraudulent prescriptions. Now keep in mind PDs deal with a lot of shady characters who maintain their innocence with increasingly implausible stories, as the evidence gets worse so you can get a bit jaded after a while. But you don't have to believe your client's story to represent them vigorously. So, the prosecution has grainy surveillance video of someone who looks like the defendant getting the prescription filled and the ID used to fill it, which belongs to the defendant. Defendant maintains that someone stole his ID and is using it because they look similar, but never reported the ID as stolen. Wife is skeptical that the jury will go for that, but she's always willing to go to trial if that's what the client wants, so preps that defense and heads into trial. Prosecutor brings in the pharmacist who reported the prescription issue, goes through the usual routine of establishing who she is, where she works, was this the ID used that day, etc. Finally, the prosecutor asks the pharmacist if the person who attempted to fill the prescription that day is in the courtroom. No. Oops. Edit grammar clarity. Story 27. Parents were being sued by their landlord, and parents had a countersuit against him. Parents were moving across country and found this house to rent. They did a walkthrough. Looks great. Landlord wants first, last, security, and $1,500 because they had a dog and 2 cats. Fine. It was somewhere in the $8,000 to $9,000 range. No big deal for them. They are set to move in on a Monday, so my mom flies in on Saturday to do one final look over, sign the contract, and get the key. Perfect, they are now the tenants. Monday, they arrive and the house is trashed. The landlord has moved a bunch of his stuff into the garage, shed, and one of the bedrooms. Theirs in the toilet, on the floor, garbage laying everywhere, used condoms. I can't really do this justice, but my mom took pictures and videos throughout the entire house. She calls the landlord and tells him that they are not moving in with the house in this condition. He tells her to clean the house, and hell buy the first tank of oil for the house it was empty. He tells her to do it, or he's keeping all the money for breach of contract. A lot of back and forth happens, and tons of harassing texts and phone calls from him. Court day comes, and everyone's ready to submit their evidence in front of the judge. Parents have photos, texts, the contract, videos. Landlord only has the contract. But his contract is different than my parents'. He's included a section that states they permit him access to the house for his storage needs, and that tenant is responsible for all on-site cleanup and maintenance after accepting the key. The best part was that the date of the signatures on his contract was the date they moved in, not the date my mom flew in and signed. Judge tells the landlord he's a special level of stupid, and then the judge's final remarks were about how disrespectful the landlord was to show up in shorts, a Hawaiian shirt, and flip-flops in his courtroom. He never paid a dime, then claimed bankruptcy, and started a business under a different name. 2 years later, I went to his house, let out all but 19 pounds per square inch from all his tires, and superglued the caps on the valve stems. Story 28. My ex-girlfriend's father had a case where he brought in a decoy defendant. He then asked a key witness for the prosecution to identify the suspect in the middle of court. The witness turned and pointed to the decoy defendant, who was just a buddy of my ex-girlfriend's father and had nothing to do with the case. The witness was caught lying with his pants down, and the whole thing was hilariously embarrassing for the prosecution. Turns out, even if you're right, it's a huge no-no to trick witnesses like this. My ex-girlfriend's father had to go through an ethics investigation and was suspended from trying cases for a while. Edit to those asking why it was a no-no. I have no idea, but apparently he violated a couple of court procedures and broke a state law. An actual lawyer might be able to comment more on it. I assume there's some law that the real defendant has to actually be at his own court date and you can't have a proxy maybe. Story 29. When I first started practicing, I handled a custody case where my client mom had a problem with dad smoking around the kids. I asked him if he regularly smoked around the kids, to which he replied that he doesn't smoke tobacco, only weed in the house. Obviously, this raised eyebrows as it is illegal in my state. He then went into a long diatribe about how he only follows the law of the streets. He actually said this and doesn't recognize the authority of the court he was currently in front of. Needless to say, mom got full custody, especially after dad was arrested for going to the court services officer's house late at night and trying to kick her door in. Story 30. NAL, but work with lots. We deal with car accidents, and this particular girl was claiming severe whiplash and lower back injuries from a minor rear-end accident. Some of her injuries were legitimate, but she was claiming that her life was ruined and she was unable to function in society. She worked as a physical therapy aide studying to become a PT, so she knew just what to say. But she didn't know what not to post on Facebook. She claimed she was in constant pain after the accident and couldn't go to the gym. The day after the accident, there's a pic of her lifting weights, #accident can't hold me back. She claimed a month of lost wages, but there she is in a patient graduation from treatment photo on her work's website the week after TGE accident. She missed 0 days of work. She claimed that she couldn't travel anymore, and guess who had photos of Vegas strippers all over her Instagram for her sister's 21st birthday? She asked for $200,000 and she got $9,000 for the legitimate injuries in mediation, as the mediator laughed at her Facebook feed. Story 31. Plaintiff was claiming insurance money because he accidentally chopped off his fingers while cutting bamboo with a machete, and the insurance company, our client, refused to pay the insured amount. During the hearing, the plaintiff attorney began to demonstrate with a rolled-up sheet of paper how his client was cutting the bamboo when the accident happened. No matter how he tried, he could not reproduce the position of the fingers with the alleged cut of the machete. The only possible match would be if the plaintiff had deliberately extended his fingers over a plane surface and hacked his own fingers. Based on this disastrous performance, the judge determined an expert opinion and later dismissed the case due to deliberate self-mutilation. Story 32. My family did foster care for a few years, and we fell in love with the last girl we took in, now my younger sister. She was required to keep in regular touch with her emotionally and physically abusive birth mom, the intention being for them to eventually reunite. This woman was a horror. Every single time they interacted, she'd spend the duration painstakingly shredding my sister's self-confidence. My parents worked hard to establish a strong rapport and a supportive environment, and she blossomed under their care. She's one of the most resilient people I know. When the state tried to return her to her mom, she didn't want to go, so my parents sued, I think. Don't really know all the legal details for guardianship. This seemed like it would be an uphill battle. Here we were, a family of randos trying to steal a kid from her rightful mom. We were really afraid that she would have to go back and that her shitty family would systematically undo all the hard work she'd done rebuilding her self-esteem. Fortunately, her mom decided to represent herself at the guardianship hearing. I wasn't in the room, but I heard the audio recording later on, and it's incredible how thoroughly this woman shot herself in the foot. Some highlights. She kept trying to testify while cross-examining people, e.g. Would it surprise you to learn that blah blah blah? The judge called her out for this like 6 separate times and she just kept doing it. She would admit to various incidents of emotional abuse, but then try to argue that it was all justified because her daughter was being a shed. Ask witnesses, for example, and wouldn't you be angry if your daughter did XYZ, yes or no? My personal favorite and the best example of her proving our case, it is absolutely not true that I hit my daughter with a wooden spoon. I only tried and missed. I'll prove it. I can show you the mark it left in the doorframe. Needless to say, we won guardianship. My sister never has to see that awful woman again unless she well pleases. Story 33. I'm not a lawyer, but a couple of years ago, my family was sued by our neighbors for having a fountain in our front yard because it supposedly made too much noise, causing our neighbors to lose sleep. So my dad, being a nice guy, said, "Okay, I'll try to fix it." We put up walls around the filtration unit and redid the pipes to dampen as much of the water splashing sounds as much as we could. After finishing all of this, my dad even got a noise technician. Not sure what they're called, to come around the house with a decibel reader to verify that the noise was virtually gone. The tech walked around a couple of times and told us that the highest reading was 28 decibels, so that we were good to go. So a couple of weeks go by, no problem. But then we get served with a lawsuit again, over the same issue. So my dad is starting to get aggravated over this, and this time decides to get our own lawyer to dispute this. Well, court day comes, and my dad and his lawyer have all the sound readouts, pictures of the stuff we did, etc. Well, the neighbors brought their evidence as well. Their strongest piece of evidence was a recording from inside their house that supposedly showed how loud the filtration unit was, but you couldn't really hear anything except our neighbor lady going, "Do you hear it? Ooh, right there. Oh, it's so loud." So when that evidence didn't bear the fruit that they wanted, they decided to show their next piece when ended their case. The next piece of evidence they tried to submit were pictures of our filtration unit, walls, and the various other things we did to dampen the sound. Well, in order to take those pictures, they would have needed to be on our property inside the walls we built. So our lawyer sees this and begins to ask them how they got those pictures, etc. They admit to the court that they trespassed to take those, and thus begins their downfall. Our lawyer showed the judge the decibel report and all that good stuff, leading to our neighbors admitting that the noise actually never bothered them, but it was the site of our ugly filtration unit. The case was thrown out, and our lawyer then told us if we wanted to countersue, we can. So we did. We got them on trespassing and harassment that they provided the evidence for. As it turns out, they were also upset at the fact that the HOA made everyone move boats and trash cans to the backyard. So our neighbors were upset that we got to keep the filtration unit in the front. Like really? TLDR neighbor said koi fountain made too much noise, took us to court, brought evidence that incriminated him in another crime. Case thrown out. We countersue and win. The fish are happy. Story 34. Best I ever saw was a psycho neighbor. Their name is Fig Jam, which stands for I'm good. Just ask me. We had that used to move to a new place, pick fights with neighbors on all sides, move rinse and repeat. Massive piece of in general. Well, one day their neighbor Jim over their back fence got a bizarre legal document stating their intent to sue over a tree in their yard whose roots had supposedly moved 20 meters down the hill to restrict and break their pool pump and the piping for said pump. So, Jim in his defense pulls in a plumber who happened to be a mate to dig up the trench and extract said roots for DNA testing in a lab. When they did this, they spared no expense. We're talking 15 people on site. We're talking bobcats. The works to make it the most expensive trench they could. Funnily enough, the DNA tests proved it was from Fig Jam's own tree, which was a lot closer to their pull pump. Who'd have thought it? They were liable for cost of their Jim's legal defense. The plumber and the lab hit Fig Jam with a $30,000 bill. Couldn't have happened to a nicer person. Story 35. Not a lawyer, but I had a legal dispute settled this way. Had a car crash, in which both myself and the other party were driving towards each other, both too quickly around a corner and crashed. A few minutes after the crash, another driver who knew the other driver in the crash arrived on the scene and offered to act as a witness, despite not having seen the crash. In this witness description of the event, they started off by describing the roads as totally blocked by hedges, with no visibility of the traffic ahead. They then went on to describe how they could see my driving as way too fast for the conditions, having seen me from miles ahead. Obviously called them on the contradiction and got the blame split 50-50. Story 36. I do only civil litigation. You would think it would generally be a battle against equals. Professionals versus professionals. It's not. I face a fair amount of parties representing themselves pro se, often otherwise smart people who wouldn't think to do their own plumbing or operate on their own appendix, but have no qualms about appearing in court on their own behalf. Surprisingly, they don't know what they're doing. As one of my favorites, from a deposition we didn't pay company X's invoices because we heard they were going through bankruptcy. A, they weren't, and B, it wouldn't be a valid defense to non-payment if they had been. Story 37. Not a lawyer naturally, but a friend sat on jury duty recently where this happened. The defendant was being prosecuted for attempted murder, shot a guy, and he claimed it was self-defense. Prosecution started and made their case, brought witnesses, etc. After 2 days in court, when prosecution rested their case, the judge said that even in their version of the story, it was so obviously self-defense that the defense didn't even need to speak. He threw out the charge and the jurors got to go home. Story 38. I'm not a lawyer, but as an arborist, I get asked about trees and the law all the time, so I know a lot about tree law and stay informed on it. Occasionally, I get called to a property to write a letter indicating that my prospective customer's neighbor's tree is dangerous or needs to be pruned or whatever, and at least half the time it's not true, and the person is amazed that I won't just write the letter anyway. Sometimes, if they're real about it, I'll visit the neighbor afterwards. If anyone is curious, in the US&A, you have the right to prune or remove, and the responsibility to maintain all plant material on or over your property. This means that you can cut back branches growing from trees from other properties without permission, and that if you neglect to do this and damage results, it's on you. Story 39. I once had a district attorney indicate to the court that if defense counsel had included this argument in his motions, it would possibly be a valid argument. I interrupted him with the page number and heading where it was located. Story 40. Not a lawyer, and I guess not them proving their case but them shooting themselves in the foot. But I took Apple to small claims court over refusing to fix my MacBook. The store leader from the Apple store in question appears for the defense, to which the judge says, "No, you can't do that. You either need to be attorney hired by Apple or Tim Cook himself." The guy says he understands but just wants to try and rectify the matter by getting the laptop fixed. Judge grants a continuance for us to come back 2 weeks later after Apple's had a chance to fix the laptop. Sure enough, they got it fixed and comped the whole repair. We show up 2 weeks later for the follow-on hearing, and it's a different judge, who's booking through the docket like his lunch is getting cold. We come up and the judge's first question to the Apple employee is, "Are you a lawyer?" "No, but this is just a continuation, and I believe we resolved the matter." Judge asks why we didn't just file for dismissal if the laptop was fixed, and I said, "Well, Your Honor, I appreciate Apple fixing the laptop, but I gave them ample opportunity to do so without suing them. Now I'm out 60 in court costs, because that's apparently what it took to motivate them. I'd like them to cover my costs." I was suing for replacement value of the laptop $1,000, so this was a huge bargain for Apple. But this dumb contested. Says they shouldn't have to pay the court costs because they weren't obligated to fix the computer. The judge, still at breakneck speed, said enough, you'll split it. Judgment in favor of the plaintiff for 30. I'm a huge stickler for principle and wasn't happy with this. And the state code actually explicitly said that as the prevailing party, I was entitled to all my court costs. So I emailed the paralegal at Apple who had previously emailed me just advising that they were contesting it and would have the store leader appear, CCED the guy, and told them both, "Look, you owe me 60, here's the section code. We can save ourselves all a lot of time and you can just remit me 60 and well be done. Or, if you only want to send the 30, I will appeal the decision to circuit court and those costs will be 130. They had, as Apple does, been snobby through the entire time, thinking they're above the law. Note twice they've been told they need a lawyer, and neither time they sent one and said, "Nope, you're only getting 30. So, I appealed to circuit court. I now was spending 130 to recover an additional 30. Circuit court is big boy court, so I'm thinking, they have to be hiring an attorney now, which means either they're stupid enough to waste hundreds on this, or they should settle to avoid that. Show up on our hearing date. There's the same store leader again. Our case is called, judge's first question is, are you a lawyer? Apple apparently anticipated this, and this guy had a letter from Apple's general counsel saying, yeah, we will allow this guy to argue on our behalf. The judge says that's fantastic that Apple is allowing it, but the court would not. Guy from Apple then goes, oh, well then can we request a continuance so that we can determine our next steps? Judge asks me if I object to the continuance. I say yes, Your Honor. I absolutely do. Apple has been told twice before this by the small claims judges to get a lawyer, and has both times flagrantly ignored the court's request and seems to think they don't need to listen. Continuance denied, and Apple Bro was ordered to sit down and shut up. I basically go through my recap of the case and why the code says do the full costs, and now also the costs for the appeal. Apple Guy tries to pipe up at some point to contest something I said, and judge had to, meaner now, tell him to shut up or he would be held in contempt. He was now nothing more than a spectator to the proceedings. Judgment in my favor for everything I asked for. Now in my state, after 10 days, I can file for garnishment. I emailed Apple requesting that they FedEx me the amount within those 10 days. At the time, being out this 200 was actually stinging. And they clearly learned nothing about being cocky and said, nope, our accounts payable process can take up to 60 days. On day 11, I filed for garnishment against Wells Fargo, their payroll bank. Court approved it and ordered the bank to pipe out the judgment amount, plus the 40 for the garnishment fee. TLDR Apple spent 4 weeks being cocky about paying 30, and it ultimately cost them over 200. A drop in the bucket for them for sure, but still, just bad business. How much labor cost did they waste too by having the store leader keep showing up and paralegal constantly working this? Story 41. Oh boy, here we go. Obligatory IANAL. I'm a medic, and sometimes our medical reports get used in courts. Sometimes we have to testify with it, others we don't. Sorry for the length of the stories. Some take backstory to get a full grasp. This is going to sound morbid, but my favorites are the child abuse cases, because I can write everything the kids tell me in the back of the ambulance, put it in my report, and I don't have to tell the guardian anything. Unless one of those statements include, I want to hurt and/or kill myself others. Then I can disclose the fact my patient is suicidal homicidal to the nurses and staff at the hospital. That's different. My partners usually ask me to do the PD abuse calls even if they're really simple, simply because I'm a young, small female that kids see as a big sister protective type, and they like opening up to me because my assessment is more like hanging with your older sibling than a medical questionnaire. Let me give you a few personal examples where the opposing counsel parents have admitted they're performing of child abuse. On the transfer side, I work critical care and 911 mix-up. I have the ability to run both bringing Child X from this facility to Super Special Children's Hospital for treatment for a spiral fracture on their left leg. Child X is about 45 years old, and the nurses tell me that it's a potential child abuse case. Spiral FXS are usually a sign of child abuse because of how they get them. Parents are still being allowed to ride with the kid, even though I really don't want them to. I concede and let what I thought the father of the child ride with us. Was on kid's paperwork, kid was on his insurance, etc. The guy creeped me out, but I was in the ass crack of the city, and it was late. Load the kid up in the ambo. They're really sleepy from pain meds, so I quietly dim the lights and leave my work light on by the captain's chair behind the stretcher where my monitor is resting with the kid's vitals. HR, heart rhythm, BP. The kid stirs and sees creep dude and pretends to go back to sleep, but I can see the HR monitor keep going at a slightly tachycardic pace, clearly not sleeping. So I begin to ask questions for my medical record, and I don't tell him what he initially told the nurse what happened. I pretended I didn't know. They also didn't know they were under investigation at this point. I had to be on the DL. I also asked him if he could sign for the patient, since the patient was a minor. He'll let the mom do that. I'm just her boyfriend. You're not the biological father? Nah, I've been with the mom for about 2 years now. Okay. He says that child X was rolling off the couch, and he caught their leg to keep them rolling off. A 45-year-old would have been just fine rolling off the couch theoretically. I let go when I heard a pop. Did you grab them by the ankle or thigh? Calf or ankle, I don't know, they slipped. At this point, child X begins to whine. I can't blame them. We were going down some pretty crappy roads. I asked Creep Dude to scoot over so I can make sure the immobilizer is still in place. I used a pen light to see, and I keep the kid covered in blankets. I see a big blotchy handprint on the calf starting to form, but also on the thigh. Like someone was twisting it in a big Indian burn, except with bone. I readjust it, cover the kid back up, and ask if me and him can switch places. I put the monitor at the kid's feet so I can still see it, and the kid relaxes and almost immediately falls back asleep. So wait, I'm sorry, I was distracted by Child X's vitals? Can you tell me what happened again? Smiling sweetly. Oh yeah, sure, baby girl. I grabbed them by the thigh and kept them from rolling off the couch after I told them not to. Were they doing it a lot or roughhousing? They were annoying me, but I didn't want them to get hurt. So you grabbed them by the calf? Yeah, the calf. I put that entire conversation in my report, and when we got to the children's hospital, I told the charge nurse what happened and privately showed her the now obvious handprints. Technically, the creep dude wasn't wrong. He did grab the kid by both the thigh and calf, but he contradicted himself in conversation because the story wasn't true. And I think that he might be thought he was in the clear since the bruises hadn't quite formed yet or he didn't see them. The kicker, the kid came to before I started to leave and thought I was big sister. Ash, not my name, make sure Dan doesn't hurt you too. Creep dude went to get mom and other siblings, but I got to watch the shit show of him being violently arrested. Without that convo in the ambulance, they might not have had the evidence. I know it was only my word versus his, but my documentation is a legal document. And I couldn't put mechanism of injury, asked Guardian. Guardian was vague and conclusive, read the following statements from Guardian. So, dude got quite a bit of a fallout from it. He got walked past my ambulance on the way out when we were cleaning up. He was spitting and cursing at me, calling me every name in the book, saying he was going to come find and rape me. Fun times. Another shorter story was when I got called out to another DV case, where the mom just blatantly admits she gave her baby heroin to help her sleep. That was a pretty open and shut case. Baby almost slept forever. She didn't tell the cops what she told me, but my documentation along with hospital records got the kid taken away and her put in prison. My favorite morbid, but I got to help a child, so it makes me feel better about what I heard, was when Granny and Mom were trying to get their stories straight, and I was behind the door without them knowing. I was just waiting on the nurse for patient report before I got in there. Granny, now, we say that he spilled hot water for coffee in his lap, right, when that ambulance driver gets in here? Mom, Yeah, they don't need to know about JD, he got enough charges already. Granny, why JD giving him a bath anyway? Mom, I DK. I was out with Keisha getting my nails and weave. We was gonna go out to the club later and JD said he'd be watching him for me. Granny JD told me he wouldn't stop whining and crying and he was giving him a bath. I pulled the charge nurse in with me and made the SSH motion. She was listening now too. G, why was he crying in the first place? M, maybe he was hungry or some. I haven't been home in a few days. I don't know what JD's been feeding him. G, I gave him a bottle while we waited for the amber lamps and he sucked it right down. Me, mama, why is there blood in his diaper? G, I on know nuttin' bout that. We hear diaper being undone carefully. M, why his booty hole looked like it got red on it. At this point, me and the nurse heard enough. Put all of that in my report. She called the cops and CPS. You know what they told me when I walked in? He reached up and spilled hot water. I was making coffee with on his legs. No lady. Whoever JD was, burned and sodomized an 8-month-old. You're 8-month-old. It sucked to pretend to be nice to them. I wound up holding and half carrying the baby the whole ride. So many blisters popped and I don't even want to think of the internal damage. I didn't let them ride with me. I have another few stories like this in my comment history. I love helping to put abusers away, especially when most of my patients are so very helpless. My medical documentation and the fact that patients and their parents, in this case lie, helps me and the courts put the abuser's opposing counsel away. When I catch them in the lie and it doesn't match the physical evidence and/or what I saw on scene, it gets used in court. People will lie all the time. This also happens with police reports. TBH, I don't give a what your charges are, just tell me what you took because medications can kill you. I'm really sorry this became a long story. Most of my stories are this way. I just get carried away. I hope it's relevant enough. People really, edit words are hard. Edit to, thank you to whoever gave me gold. And thank you for all of your supporting comments and messages, even the argumentative ones. I don't fancy myself a superhero, I'm just doing what I was called to do, and that's taking care of people. Sometimes it's literally holding someone's guts in, restarting a heart, or simply talking, listening to them and giving them a hug, letting them know that someone does care. Other times it's bringing a life into this world and seeing the stars align in the mother's eyes, and occasionally it's seeing someone join the stars we came from. Much love from me and my nugget due in January. Y'all made me cry happy tears. Story 42. I just got a brief in the mail the other day where opposing counsel argued our side of the case. That was new. Contemplating submitting a one-sentence reply brief that simply states, we agree with. Story 43. Not an attorney, but I did an internship at the city's attorney's office one summer, leading to not wanting to be an attorney. Man was suing the city for evicting him from a public housing development. Claims he doesn't speak English and forced the city to hire an interpreter for the hearing. City says he was evicted because he was raising chickens in the apartment. His attorney insists that's absurd, no one would do that. Pushes for proof the chickens were his clients. Judge wasn't convinced about the proof. Everything looks like it is going well for the guy until it comes up that the chickens were given to a farm for slaughter. Guy jumps up and starts yelling, "Give me my chickens back," in English. Judge starts laughing. Attorneys start laughing. Case is dismissed. Story 44. My wife is a court clerk. She told me a story a court clerk friend of hers told her. DA has a shaky case at best against a defendant. Police were trying to pin a drug charge on a guy with literally zero evidence. The report read that a certain amount of weed and meth were found and recovered in the defendant's car, but the evidence was lost. Guy maintains his innocence and has no priors. The defense attorney is destroying the officers on the stand for inconsistencies between their accounts and poor documentation on the official police report. The prosecution's ace in the hole was a part of the police report that read something to the effect that the police K9 said there was marijuana and meth and in the car. Rather than saying something like the police K9 alerted the officers to the presence of drugs, it left the defense attorney no choice but to call the police K9 to the stand to confirm its testimony. DA drops the case. Story 45. I'm not sure that opposing counsel has ever managed to prove a case completely, but there are constantly errors that make my job a lot easier, particularly as I become more senior and more often have opposing counsel that is less experienced and able. Important to keep in mind that I was once the junior party and probably made many errors I didn't even know I was making. I honestly look back at some of the early mistakes I'm aware of and feel mortified. I expect this is common to most professional people. I'm just glad I'm not a doctor and didn't kill anyone. Story 46. Did work experience at a trial where the victim flat out stated the defendant was innocent. Turns out she's pretty bad at English, so when she gave her account, it appeared that the defendant had committed a crime. They then gave her a witness statement to sign. She can't read no good, so just signed it anyway. This all came out at testimony, whilst the prosecution lawyer desperately tried to get her to rephrase what she said. Funnily enough, the trial wasn't immediately thrown out, so they brought more witnesses in to testify, all backing up the wrong account of what happened. Story 47. IAAL. This was a restraining order case. My dude had allegedly been within 500 feet of his ex. At trial, it came out that she had told my guy that she had told him the restraining order was dropped. Hence, he couldn't have violated the restraining order willfully. Judge got furious and dismissed the case. Story 48. I was an attorney for the estate of a husband defending against claims for money by the separate estate of a wife over proceeds from the sale of a business back in 1996. Both husband and wife died in 2010. Suit was filed early 2011, went to trial in 2014. Wife got around 10 of the business in 1996. Husband got the rest. He had built and operated it for 35 years prior to marriage and sold it 7 years into the marriage. The whole case hinged on whether the valuation of the business in 1996 was reasonable or not. We say you can't value a business 15 years later with all the documents gone and all the main people in the business dead or missing. They say they have enough info to show the 1996 valuation should have been higher. Opposing counsels gets a big-time expert to testify that the business sold of $45 million based on a valuation, but should have sold for $70 million, and the husband hid $25 million in real estate in the transaction. We get that testimony and then realize the 1996 valuation of the business was done by the same expert. This is the absolutely most perfect catch-22 I have ever seen. So now we ask, okay, so was your valuation wrong in 1996 or is it wrong now? Expert says his 1996 valuation was right based on the information he had in 1996, but his valuation now is more correct. Which then bears the question, what information do you have now that you didn't have in 1996? Answer: I don't know. I don't have my file from 1996. Nobody keeps documents that long. And despite this lack of records, his valuation is somehow more correct now. Judge basically said the expert was talking out of both sides of his, and we won. Story 49. Obligatory. I'm not a lawyer, but my dad worked for a company that got bought out. New owner owned the company, old owner still owned the land building, new owner rented those from old owner. The old owner was a good boss, treated employees right, ran the business well. New owner not so much. Real piece of dyke wanted my dad to do airport runs on Easter Sunday. The new owner would sometimes just not send paychecks. He knew he owed his employees money, just wouldn't pay them. My dad had enough and left. Fast forward 3 years later. Old owner was suing new owner because new owner wasn't paying the rent. My dad gets called to witness as a former manager employee. New owner's lawyer is questioning my dad. He asks, well, why did you leave XYZ company? My dad, honestly? New boss's lawyer being a smartass, no, I want you to lie in a court of law under oath. My dad, well, I left because new owner wasn't paying me. There was silence, followed by no further questions. Story 50. I did not prosecute this case, but I saw it. The state was prosecuting an individual for reckless conduct with a deadly weapon and criminal threatening with a deadly weapon. It was a bench trial because the defendant was a foreigner, and I guess the defendant was concerned that a jury would be biased against him. Essentially, the state alleged that the defendant waved a gun at 2 employees of a Dairy Queen and then discharged the gun in the air. The defendant was the manager of the Dairy Queen. So at the start of the case, the state requested a continuance because it could not produce the 2 employees. They had been subpoenaed but didn't show. The judge denied the continuance. So the state decided to go forward. It put on its case, but wasn't able to introduce any testimony that the defendant brandished the gun at the employees or that he had discharged it near them. There were admissions that he had had a gun that night which he had shown to other people and testimony that the gun had been discharged. State rests. Defense does not move to dismiss and calls the defendant to the stand. I was watching in the gallery with some public defenders because trials were uncommon in that county. We immediately began whispering to each other about how he didn't do the motion to dismiss at halftime. The defendant testifies about how he wanted to scare the two employees as a joke. Then on cross, he testifies how he brandished the gun and what angle he was holding it when he fired. Defense rests. The judge had the longest delivery of verdict that I have ever heard. He said something to the effect of, "It is rare that you find a defendant that convicts himself by his own testimony." But that is what happened here. Without the testimony regarding the gun and the discharge, there would be insufficient evidence to convict. He goes on and on. While the judge was delivering the verdict, the defendant was standing obviously. He faints and slams his head on the defendant's table. He ultimately was taken out of the courtroom on a stretcher and transported to a local hospital. There was blood all over the floor. The defense attorney, who was in his 60s, looked like he needed medical attention too. This would have been instant, ineffective assistance of counsel. But he was immediately deported, which is the main reason he went to trial, because he was also a convicted felon, though not charged with felon in possession in this case, and INS was only waiting for the conviction to deport him. So he was sent back to his home country. This was the most messed up thing I have seen in court, and I have seen some wild. I felt bad for the attorney, but ultimately contacted lawyers' assistants about him because I saw him do other things that were almost as bad. As a prosecutor, I was worried about his clients who were paying him for the most part. The court was no longer appointing cases to him and his ability to effectively represent them. Story 51. Not opposing counsel, but the plaintiff himself. I was trying a case in DeKalb County, Georgia, against a guy who claimed he had slipped and fallen in a Kroger store late at night while they were waxing the floors. He claimed the only signage anywhere near where he fell was a single yellow caution sign, more than 85 feet away. We had a surveillance video, and it indeed showed him passing by the sign as he entered the aisle. However, arguably, the sign didn't really indicate what was going on, since it wasn't apparent the aisle was being waxed, and it was quite a distance from where he fell. On the stand, at the end of the first day of trial, I was cross-examining him about the signage, and he made a comment in which he referred to passing the signs plural. It is very unusual to learn a new fact at trial after typically 2 years or so of depositions and discovery. I stopped where I had been going with my questions and asked him about the signs, and he admitted he had taken pictures of them and had them at his house. Well, this is a clear discovery violation, since he's required to turn over all pictures, not just some, and we had clearly asked for them. However, when I went after the guy for concealing evidence, the judge chewed my rear end for getting into a discovery dispute in front of the jury. I still think she was wrong, and I got him to agree that he would produce the images the next day. We adjourned day 1 of trial. The next morning he showed up with the pictures, and it turned out he had walked directly between 2 caution signs, set up on either side of the aisle like the Pillars of Hercules. There was no ambiguity whatsoever about his notice after that, and the jury gave him $0. Story 52. Former lawyer here. This happens with pretty good frequency, but not at trial and in a different manner than you are thinking about. In my direct experience, the most common way the state got one of my clients off the hook was via forensic subpoenaed evidence that takes some time to come back. However, this happens well before the trial. It goes like this. There is a violent crime and evidence is gathered. 2 eyewitnesses swear they saw my client at the scene. Cops arrest my client based on eyewitness accounts. I meet with client for the first time. He swears he's innocent and was at his girlfriend's house at the time. A few days later, cell records come back and forensics come back and proves that my client was elsewhere, and I get him immediately released. Because I'm sure to be asked, I practiced in NYC in the pre-video cameras everywhere era. Eyewitness accounts were the first and fastest avenue for cops to ID a suspect. It was very common for rival criminal outfits to falsely snitch on each other to get the competition off the streets for a few days or just to with someone they didn't like. From the cops' perspective, they get put in a bad way if there's, say, a murder, and you have 2 to 3 guys who one swear up and down they were right there and 2 swear up and down that they saw the suspect commit the crime. The cops aren't really in a position to not arrest the suspect pending further investigation. Story 53. My dad is a lawyer. It's happened several times that the defendant submits or provides video evidence of assault or unlawful detainment, but assumes it will go unnoticed in 50 hours of footage. My dad watches everything. He got a multi-million-dollar settlement from a major casino after pointing out a moment that proved video doctoring. Edit. There was a car one too. He had a bunch of recordings and found a spot in the recording, submitted by the other side, where they are discussing what they need to show and how they will prove it. IRC. He played the recording in court as a surprise. They had nothing to say, and he won after like 4 days of back and forth. I believe you have to get to a point where that evidence would come up. That's why he couldn't start there. My dad is a total. Story 54. Not very interesting, probably. I work in land law. Had a guy file against us one time for adverse possession of about 20 acres of pretty valuable land. Adverse possession is a legal method to acquire legal title to property of another after some duration of time passes, and other factors are met open, obvious, and hostile possession, etc. Long story short, the guy sued his neighbor, our client, due to a fence being placed in the wrong spot. Both sides assumed it was their property line. Turns out after being surveyed it was not, and actually those 20 of our acres were on the plaintiff's side of the fence, and that fence had been there for a long time. Anyways. In their pleadings and evidence, they tried to put on their strongest, most persuasive evidence by saying the plaintiff had been on the property forever and had always used it, worked it, etc. That sounds all good and great, except their lawyer didn't know the law well enough. Which brings me to the one other important fact: the plaintiff was our grantor and neighbor. Basically, he sold our guy the land, then sued us years later to try and take it back. How is that? Truth be told, the law permits a grantor to adversely possess land previously conveyed, but there's a little sneaky exception to that. If the grantor continued to stay on the land before and after the conveyance, the adverse possession clock never starts ticking unless he takes another act, a thing he didn't do. So in all their huffing and puffing, swearing they'd been on the land from time immemorial, they really just killed their own case. It didn't take discovery, a deposition, nothing. They just unintentionally presented their own legally fatal evidence in an attempt to bolster their client's claim to the land. Thereafter, all it took was one fairly long letter explaining this, and the case was dismissed after a nominal payment from us, basically buying off their appeal to not waste our time, as no attorney fees were in the mix. As I stated above, this probably isn't very interesting to anyone, but it sure gave us a good laugh and a story to tell. Story 55. Not a lawyer, but my dad was one. He was defending someone charged with a DWI. The arresting officer's testimony got my dad's client off. When did you observe the first traffic violation? At the light at X Street. So you observed no infractions before that light? Correct now. About half a mile before that light. Did you notice the sign that said "Welcome to Connecticut"? Officer had no jurisdiction. Case was dismissed. Story 56. Obviously. I'm not a lawyer, but this is about 10 years ago now. I was driving on a freeway, spur traffic had backed up at the end of it. I stopped, and a very large pickup truck behind me did not. My poor car, a special edition Saab 900 SPG that I loved, was utterly totaled. I did not have collision insurance coverage, but no matter because it was 100 the other guy's fault. His insurance company offered me $750 or something ridiculous because my car was 1 year too old to be in the regular Kelly Blue Book of Values. They were unwilling to be reasonable, so I filed a claim for $3,000 in small claims court. In my head, I felt that was still a bit low, but not a lot. And at the time, $3,000 was the maximum I could go for in small claims. Outside of small claims, I would have probably needed to hire lawyers and stuff to feel more comfortable about it, and I wanted to avoid that. Went to court the first time, and my opponent had 2 lawyers. The lead lawyer guy looked almost cartoonishly slimy, as an aside, and an automotive inspector adjuster for a witness. We waited to go before the judge, but the docket ahead of us ran long, and we got rescheduled for another time the next month. No problem for me. On the new court date, we all showed up again except the inspector adjuster witness. He couldn't be there, so he was allowed to testify via telephone. That turned out to be important. Now in court, before a judge. In response to the judge's questions, after testifying on various little inquiries about how much I had bought my car for originally, any work I'd done to it, etc., I presented a page from the classic car edition of the Kelly Blue Book, which shows valuations for cars that are too old to be in the regular edition. It said my car, if in normal condition for its age, was worth $3,650. It was clear to me that the insurance company had said to themselves, well, the car isn't in the regular blue book, so we can just do whatever we want. Sure, let's say it was one step above scrap metal. At first, the opponent lawyer said that no, my car wasn't a classic car, like the kind you'd see in an Independence Day parade. But that's just the name of the Blue Book. Any car of a certain age can be listed in that edition, regardless of whether it's a mint Chevy Bel Air or just an old Datsun or whatever. The judge recognized that, so the opposing lawyer then argued that my car was in such poor shape that it should not qualify at the normal condition value. Because the opposing witness inspector adjuster was not physically at the hearing, he was not aware of this change in approach. At that point, the opposing lawyer called his witness on the telephone and had him offer his expert opinion on the value of my car. Having not been present for the new tactic of arguing that my Saab was a complete rust bucket, the lawyer asked him if the 20-year-old car was in excellent condition. His exact reply was, no, it was in average condition for its age. Bam! He'd just proven my case. Oh man, was that satisfying. After a few questions from the judge to button things up, she said, okay, so ceiling 99, do you have anything else to say for yourself before I find in your favor? Haha, I got the full amount from the Blue Book, so a bit more than I even requested in the court filing. State Farm. It happens more often than you would think. One attorney that people continue to hire, Brian, is sort of a legend. As opposing counsel 4 times in 6 years, he has lost cases against my firm where he could have won. This is civil litigation, but the guy has a knack for spoiling his momentum. One in particular, the evidence pointed to our client was at fault, and we were asked to settle. Brian introduced a witness and voicemail to the record. We had no knowledge of these and asked to review. Upon review, we were confused as the voicemail had nothing to do with proving their case and made the plaintiff look like a lunatic. It was full of incoherent rambling and swearing. We allowed the exhibits to be entered and they went over as we expected, and we won the counterclaim. Story 57. I was on the stand, not a lawyer, but the victim of crimes, and my rapist lawyer asked if I was ever under the influence of alcohol. They were trying to paint a picture that 14-year-old me made up these stories about my father raping, so I could party and go into foster care to do so. I answered honestly and said, yes. The lawyer got a smirk on his face and asked his follow-up question, who supplied these to you? I forcefully pointed my finger at my father, who was in his orange jumpsuit and shackles, and announced, him, my dad. He would get me drunk. Felt amazing. Story 58. Lawyer. Here had a trial where the basic elements of the claim against my client amounted to 1, that he abused opposing party, and 2, that she was in threat of future abuse. All nonsense, but that's what they needed to show. We get to trial, an opposing party who was supposed to be unrepresented shows up with 5 lawyers, 2 advocates, and 2 interpreters. But this is a family law issue, and these lawyers are from a business law firm. I'm curious where this will go. They put on a case that never once mentions any abuse or threat of future abuse, and end by proving that she had secretly moved to another town prior to filing the motion, meaning that he couldn't pose a threat to her because he didn't know where she was. I just pointed out to the judge that there was no need for me to put on a case. Story 59. I represented a client who was defrauded into purchasing a bad business. The defendant was not willing to settle, and all settlement talks eventually halted. Also, the defendant's attorney was pretty slimy and told me they didn't have a lot of the records I was requesting because her computer crashed and had to be formatted. The defendant got a new attorney a year into the case, and her new attorney told me about all of these records his client had, several of which proved my case and were supposedly destroyed in the computer crash. His client was clearly not happy. A settlement was reached shortly after. Story 60. The vast majority of the time, it's not an opponent who directly proves up my case, but the experts he/she hires instead. It's only happened twice in my relatively short career, but these types of cases usually settle real quick after the shortest depositions of my life. L. Do you have an opinion on what may have caused plaintiff's spinal condition? D. Yes, L. In your opinion, within a reasonable degree of medical and surgical certainty, could it have been what happened to him at work? D. No, a lot of doctors charge for a pre-interview before a deposition, and a lot of attorneys hate paying, so I understand how this can happen, but I've got to feel for the guy at the end of one of those deps. Story 61. During my husband's divorce from his ex-wife, she demanded that everyone involved be put through a psychological examination to prove that my husband is an unfit father. She lost custody of the kids after that one, Story 62, IANAL. But the opposing party made it easy for us. We were tubing down a small river in rural Ohio. We had only been in the river for a quarter mile when we get stopped by rangers doing checks on who knows what, probably for people drinking. They stop us, and after 30 minutes, tell us that we have to leave the river and give us a ticket. When my dad asks why, they say it is because the boat that my 4-year-old brother is using is not licensed by the state, and that it does not have the mandatory safety equipment on board being life jackets, medkit, and fire extinguisher. I'm on mobile, so I can't post a link, but the boat is something you get from a Toys R Us for your pool. Long story short, my dad fights the ticket and, per their request, brings the boat to the courtroom. He said he walked in with the boat folded and tucked up under his arm. The judge asked, "Is this the boat in question?" My dad said, "Yes, Your Honor. If you give me 5 minutes, I could blow it up for you." He also went on to say that if the safety equipment was in the boat, that it would sink. He won right then. The court costs were as much as just paying the ticket, but it's the little things. Story 63. Actually, yes. I was suing the state for damages in an illegal operation by the state police here in Brazil called military police, or Polícia Militar, but there were hardly any proof. All the witnesses were too intimidated by the cops to talk. There were no images or audios. I advised the guy that his chances were slim to none, but since I was working with the public defendant office, I couldn't deny the case just because there were little proof. So I did the complaint anyway here in Brazil called an action, or AO, and we went on. In Brazilian justice, the writing part is way more important than the hearings and the talking part. So, when you defend yourself from a suit, you make a piece in writing, called contestation contestao, and there you must present all your defensive arguments, and cannot present new ones later, unless you can prove that it couldn't be obtained or be known earlier. So, when the state presented its contestation, it didn't have anything but a single paragraph saying that the cop was not under orders, despite being in uniform and in a police vehicle, when he committed the illicit behavior. Basically, they confessed to the cop brutality and gave us the case. Story 64. IAAL. I'm an immigration attorney. We're at a hearing for a motion to reopen removal proceedings, that is, deportation on the grounds that my client was never served the notice to appear NTA. My client had been ordered removed in absentia because he never received the NTA. He could have shown up and disputes removability, but he didn't even know he was being removed. ICE attorney says my client is lying, that they sent it to the correct address. The immigration judge IJ asks what address ICE sent the NTA to, as the Immigration Service USCIS had multiple addresses on file. The ICE attorney opens her file, pulls out an unopened envelope, and reads the address off the envelope. The judge asks to see the envelope. It had the big yellow "Return to Sender," address incorrect, undeliverable sticker on it from USPS. Judging by the look on the ICE attorney's face, she only realized what she did, that she was caught in her lie after she had handed it to the judge. Judge ordered the removal proceedings reopened. That is, my client's outstanding removal order was rescinded, and we were allowed another hearing to argue against removability. TLDRICE lied about serving my client deportation notice, handed the judge the envelope with "Return to Sender" still on it. Story 65. Not a lawyer, but this happened with my parents. One day in 1993, my sister and I were on our way home from school and daycare with my dad. We were both in the back seat, and like most siblings, we were fighting. We pulled off the freeway, and my dad turned around in his seat to swat at both of us. Then bump. He had hit the car in front of us. We pull over. It was minor, no damage to either car, but the woman driving the other car swore her neck was hurting. The ambulance came out and checked her over, gave her the okay. Then she starts arguing with the medics. She demands a neck brace. They tell her she doesn't need it. They give her a neck brace. She wants a ride to the hospital. They say no, she demands it. They tell her that they deem it medically unnecessary. And I distinctly remember one of the cops rolling his eyes when she demanded it. Cut to 7 years later. She has burned through 6 lawyers, several doctors. She is suing my parents for $1 million. My parents' insurance company had offered a $500,000 settlement, and they declined. They are certain they can win at trial. It's the end of the first day of trial. The woman is on the stand. It's about 3 p.m. She's talked about the pain and suffering her and her husband have endured because of it. My parents' lawyer walks up to the stand with a photo. He asks her to describe the vehicle that hit her. She testifies she absolutely clear as a bell remembers looking in her rearview mirror at a white pickup truck coming at her and plowing into her at 60 miles per hour. He turns the photo around. "Do you recognize this car?" She answers, "No, I've never seen that car before in my life." Her lawyer panics and asks for a recess for the evening. My dad has never owned a truck. We had a dark blue 1992 Ford Tempo. The jury sent the guard to ask my parents' lawyer if we wanted any money. We asked for the lawyer's fees only. The jury found in our favor and awarded us $200,000, which covered 7 years of lawyer fees for defending against an ambulance chaser. Reddit, she was in another car accident the following month. Story 66. Like all the other posts on here, not a lawyer, maybe a cop. Anyway, I had to involuntarily commit a subject for a mental health evaluation after they drove across the country and called 911 and made a ton of suicidal threats to the dispatchers and to me when I arrived. A few days later, I received a subpoena to testify at the commitment hearing. She was ordered to stay longer than the 72-hour evaluation period and is entitled to a hearing. She was fighting the commitment. Okay, I think. This lady is nuts, but she can fight it. Well, let a judge decide. I get there and testify to what she said to me, how she was acting, the threat she made to herself, and I rest. She gets on the stand and it's like a 180 from when I first saw her. She's calm, cool, and collected, and doesn't appear to be in the manic state I first saw her in. But about halfway through her testimony, she has a complete breakdown and says, "I can't do this. You all are wasting your time. You need to get me out of here so I can go kill myself." The judge just looked over at me and said, "You can go." Story 67. I'm a patent attorney focusing on patent prosecution. This wasn't my case, but a friend of mine at my firm. To give just a bit of background, in patent prosecution, we draft a patent application, submit it to the USPTO, and have an examiner tell us all the reasons they think it's not patentable. We can then amend, argue, or both, and go back and forth until we get an issued patent or abandon. The examiners primarily rely on prior art, which is references they believe show that our invention isn't an invention because it already exists. So, this friend of mine had submitted an application and gotten a rejection from an examiner. The examiner had cited some art that had the very deficiencies we were trying to overcome. There was no evidence of our actual invention in the art at all, but instead it showed exactly what the problem was with the prior art. The examiner's argument was that our invention would break the internet if it were put in place. My friend went around and around with this examiner, showing him how the art he'd cited was merely evidence of the problem we were trying to solve, and didn't show our invention. Finally, he decided to appeal the case. The board fully adopted his reasoning as their decision on appeal, which was his position all along that the examiner had showed the reason the invention was necessary. Not that the invention existed, which in effect proved that the invention didn't exist in the prior art. Ultimately, all that happened was that we got a granted patent out of it. Story 68. My father is a physician and occasionally serves as an expert witness in some cases involving insurance payouts for car wrecks. He had just spent some time explaining all of the different forces involved in the accident, and how that could translate to years of back problems, his specialty. He was quite technical in his explanation, and the opposing attorney thought that my dad was overreaching his expertise and was talking more as an engineer rather than a doctor. So he asked him if he was an engineer. My dad responded that yes, he was in fact an engineer, as he had a bachelor's in engineering from before he went to med school. It apparently didn't completely resolve the case, but the attorney did have to backtrack quite a bit, and it really strengthened the patient's case that the insurance company should continue paying for treatment. Story 69. Not a lawyer, but I got out of a DU. I, at 19, after the prosecution, spent 30 minutes explaining to the jury what constitutes a DUI. Turns out my particular case did not. Jury and court because I lawyered up fight it. Story 70. I'm not a lawyer, but neither was this guy. Father's business had hired a receptionist, and she had a slip and fall on the first day of work. Insurance was covering it, but her husband-boyfriend don't really remember wanted additional compensation. Though not actually a lawyer, he started civil litigation. This drug on for a while, and he eventually presented emails between my dad and his business partner. After the incident, the office had been broken into and all the computers stolen. He told the judge not to worry about where he got copies of private emails. Guy was taken into custody then and there. Story 71. In traffic court for a speeding ticket in small-town Indiana, decided to fight the ticket as the sign on the country road was covered by branches, and the officer that pulled me and my friend over was kind of a... At the end of the case, the prosecutor was giving a final statement and said, "We know that everyone speeds down that stretch of road, so clearly I was too." The judge stopped him right there and dropped the case. Story 72. I represented a woman who was on Section 8 and whose landlord was actively trying to evict her without cause. She walked into my office 3 days before her trial was set to take place. Typically, I would never accept a case with such little prep time, but this woman's situation was so pressing and her need for help so great that I just could not turn her away. She was on Section 8 because she had cancer that required extensive and costly treatment and which prevented her from working more than a few hours per week. Her daughter sometimes stayed at her apartment and acted as her caregiver because she was often unable to properly care for herself. For some reason, the landlord decided he had it out of this woman and that he wanted her gone. If she got evicted, she would lose her Section 8 voucher and would be unable to afford both a place to live and her cancer treatment stuck between near homelessness. Her daughter's apartment was too small for her to stay at, and a slow, painful death is how I saw her, even if it might have been a slight inner exaggeration. The landlord was mad that my client's daughter sometimes stayed at her apartment to help care for her, as she was not supposed to have overnight guests. In an attempt to evict her, he once called the police on her regarding a noise complaint while my client was having a barbecue with her daughter and another tenant in the outside common area. He told the officer that they were blaring music, screaming, and disrupting the other tenants. The cops came and found no evidence or indication of any excessive noise and then left without issue. There was also another tenant in the building who seemed to have it out for my client, always picking fights with her and harassing her. Whether this was at the behest of the landlord, I cannot say. During one instance, the other tenant shoved her to the ground in the laundry area, and they got in a sort of scuffle and the police were called. Again, the police made no arrests and found no evidence of wrongdoing on behalf of my client. I took her case and immediately called opposing counsel, who said that she would be more than happy to discuss settlement now that my client had counsel or consent to a continuance of the trial. Fast forward 2 days to the morning of trial, and opposing counsel refuses to discuss settlement further and makes a huge scene about a continuance to the judge. Unfortunately, the case was quite old by the time my client contacted me, and the judge agreed that the case needed to proceed that morning. I had no discovery and no hard evidence, only character witnesses to testify regarding the fact that my client was a polite and respectful tenant. Opposing counsel calls the landlord and questions him for a while. All his answers are extremely biased and prejudicial, and we go back and forth with questions and objections for a while. All of a sudden, opposing counsel pulls out 2 police reports, one from the supposed noise complaint and one from the scuffle, and hands me copies, which are marked as exhibits. Usually, I would vehemently object to the introduction of these police reports, but I asked the judge for a minute to read them since I had never seen them before. Opposing counsel, for some reason that I will never understand, had just handed me the pot of gold at the end of the litigious rainbow. The officer's notes on both reports could not have been more damning of the landlord's actions and could not have painted a better picture of my client. They were full of phrases like, "Ms. X was very polite, and we had no issues with her, while on the premises she claims that her landlord has been attempting to wrongfully evict her for some time. And we have responded to other excessive calls from the landlord regarding Ms. X in the past. We find no evidence of wrongdoing on her behalf." The music and conversation were at respectable levels and did not at all rise to the level of a disturbance. Ms. X was provoked by the other tenant, who then repeatedly tried to engage her in a scuffle. Ms. X was very respectful and fully cooperated with the officers. It just went on and on. I let the police reports into evidence, and opposing counsel questioned the landlord about them. They were attempting to use the simple existence of the police reports as evidence that my client was an uncontrollable and disrespectful tenant. How could she not be if the cops were called on her multiple times? After some objections, the judge pretty well shut down this line of questioning, and it was my turn for cross. I asked the landlord to refer to the notes section of each report and to read all of the officer's notes on both reports out loud in full. It was one of those glorious movie moments where all the heads in the courtroom perk up, to the side, listen intently, and then begin to shake their heads disapprovingly as it becomes clear that the landlord was trying to pull one over on this woman. After a couple of lines of text, the landlord realized what was happening and kept trying to stop reading each time he came to a sentence that praised my client or made a damning statement about his actions in excessively attempting to evict her. Each time I asked him to please continue, and he did so begrudgingly only to stop a sentence or two later. This continued to the point that eventually the judge took over, scolding him to read the reports in full as requested or face contempt. Needless to say, we prevailed. The woman's daughter cheered and clapped in the background, and even one or two of the other litigants watching in the courtroom while waiting for their case to be called gave a whistle or short whoop. My client got to stay in her apartment and, more importantly, keep her Section 8 voucher. I, of course, explained to her afterwards that, but for the egregious error by opposing counsel, we might have lost, and next time she needs to take lawsuits more seriously and hire an attorney immediately, needs to find a new apartment ASAP, etc. I have not kept in contact with her, but he'll never forget the pure satisfaction I received from the lawyer that laid the golden egg on her malicious client, promoting both of them to receive the disposition that they deserved. Story 73. Had a pre-trial meeting with a subject our office law enforcement had charged with healthcare fraud for not providing services to people they billed insurance for. The subject charged with the crime brought their attorney and a friend. Friend had been given a copy of discovery with witness statements. Friend had gone to the addresses on the interview reports to talk to them. Friend says one of the persons she talked to told her they never even met the subject. We say, well, yes, that's what that person told us in our interview report. The problem is the subject billed an insurance company for services provided to that person in their home. Thanks for proving our point. The subject pled to a felony. Story 74. IANAL was in court for a friend. The guy in front of us was contesting a ticket. His defense was that he was passing a car at the time, and they got the radar reading from the car he was passing, not from him. He didn't win that appeal. Story 75. My ex and his public defender. I pressed charges for him violating an active protective order. His public defender let him take the stand after a not guilty plea and describe in great detail how he violated the protective order. The judge looked at him and said, "Okay, so you admit you went directly to her residence and attempted to make entry knowing she was at home?" "Yes." "Guilty as charged, the PPO clearly states you are not allowed near the plaintiff nor near the residence." Story 76. A barrister friend told me about a case observation she witnessed during her training. A guy was up for with a minor, and he adamantly insisted to his lawyer that his defense was that he had never even seen the girl, yet alone met her. This despite witnesses in the bar and incriminating CCTV footage showing someone who looked like him leaving the bar and going to his car in the car park. When he was questioned, he steadfastly stuck to his story. When the questioning ended, there was a pause, and he yelled at the judge, "There was no way I could have known she wasn't 16 when she sucked me off." Literally, blowing his whole case. Story 77. Yes. I was representing a third-party defendant, early 1990s, U.S. District Court employer of an asbestos worker dying of mesothelioma, and the defendant who had brought my client into the case moved all of my client's documents into evidence over my objection. However, they never showed a document to the jury showing that my client had knowledge of the dangers of asbestos. There was no testimony showing that either. So at closing arguments, I told the jury that they had not seen one document showing my client had any knowledge of the dangers of asbestos. Jury gave plaintiff a multi-million verdict, and my client had zero liability. Story 78. I once pleaded not guilty to a traffic ticket for speeding after a ticket was sent to my home, camera ticket. We were eating at a fine dining restaurant. I said it couldn't have been me because I was in the restaurant trying to find out how to get to our next point. The prosecutor said something jokingly like, "You're not being tracked by the government, so we can't really go back and look." I nearly forgot that Google Maps had a timeline and asked if I could show it. The judge giggled a little after I showed him my phone and got the ticket canceled. I'm pretty sure the valet drove my car around. Story 79. Not a lawyer personally, but have seen this happen firsthand. Parents used to own a rather large nursery business, growing and delivering plants around the southeast. One day, one of our truck drivers is driving his route, and a kid playing in the street deliberately runs directly into the side of the truck because his parents told him if he got hurt, they could sue the business and get tons of money. Months of damage control goes by, the parents of the kid refuse to settle, and court date rolls around. The kid is asked to take the stand, and my parents' lawyer gets up and starts telling the kid how strong he looks and what a good football player he bets the kid is. To which the kid replies with an array of cocky responses. Lawyer then says it's a shame that the arm he shattered will prevent him from being the strongest kid on the team, to which the kid replies, "My arm ain't hurt. Look, I'm strong as an ox," and starts flexing and flailing his casted arm. Defense has no further questions, and the kid's parents and lawyers are just left facepalming after watching months of preparation get flushed away. My parents never lost a dime. Story 80. So not a lawyer hopefully one day, but a law student. There was this case in race equality law we learned, and essentially the plaintiff, a waitress, wanted to prove that the defendant, her manager, was discriminating due to the color of her skin. In English law, to my knowledge, to prove discrimination, you have to compare another employee of the same race, gender, or such to show indifferent treatment. Now, it was really hard to prove this as most of the abuse was verbal, but during the closing statements, the waitress started to cry of unfair harassment she received recently. Apparently, the defendant outside the courtroom during the final day of trial, in which he would have won, racially abused her in front of the judge. You pretty much know how that ends. Story 81. I had a case where the opposing party, unrepresented, was insisting she had a contract with my client. There were 4 versions of the contract as negotiations continued, all signed by my client, none signed by the opposing party. Eventually, my client got fed up and ended negotiations, which prompted the lawsuit. During the hearing, after having made lengthy submissions about how she had a contract with my client and was owed a bajillion in damages LOL, the opposing party then went on to talk about how she didn't understand the contract, and that's why she didn't sign it. The judge paused and asked during her submissions, "So, you didn't understand the contract? OP, yes. J. And so you chose not to sign it? OP, yes. J. You chose not to sign? OP, yes, I didn't understand. JK. Bye. I literally just sat there winning." Story 82. Not a lawyer went to court, yada. Traffic light out, cops everywhere handing out tickets. I get one for rolling through a red light, though I had stopped. I stated it was possible the officer just didn't see me stop and asked if any other officers were witness. Officer replied, "Every cop in our department was there handing out tickets." Judge said, "None of you thought to direct traffic? Seems like you handed out enough tickets that you recognized the downed light was a problem." Dismissed. Judge dismissed every one of the tickets that were contested in the room from that day. One cop wasted half the force's night. I hope he never lives it down. Story 83. Not a lawyer, but represented myself against an employer who terminated me. I spent hours upon hours, day after day, preparing for this case. I printed out emails, recorded telephone calls, mountains of evidence. I wore my best suit and, nervous as all, showed up ready to plead my case. When I get there, my former employer opens with, "We terminated Woe Milkerson for truancy." He was supposed to report to work after his doctor's appointment, but did not show up until 3 p.m. There's an awkward silence. The judge says, "But in your written statement, you claim he didn't report to work until 12 p.m. In the time card you presented to me, it shows that Woe Milkerson reported to work at 10:30 a.m. More silence. I won. Story 84. Opposing counsel introduced a highly relevant and crucial piece of evidence during the cross-examination itself. We were really pissed, and we had every right to argue that this was deliberate suppression of relevant documents during discovery. But rather than object to its admissibility, we asked for our lunch break to commence earlier so we could take instructions from our client as to how to proceed, which turned out to be a darn excellent course of action. The document prima facie looked supportive of the defendant's case, but it actually in substance was pretty damning for them. We basically came back from the lunch break to rub the defendant's witness face in it. And the witness was so shaken, he broke, for lack of a better word, to describe how he couldn't carry on his bullshit and completely admitted to his negligence on the stand. He admitted as well that he copied the expert's opinion, instead of giving his own independent evidence. It was a beautiful trial. Story 85. I'm a stenographer and have been in so many depots, trials where an answer is given and I automatically think, nope, that was not the answer that should have flowed out of that mouth. Story 86. I was in a temporary custody hearing when the opposing counsel drops a bomb. My client lives with his father, and the child days before made abuse disclosures against the grandfather. Well, Police report is produced, notice of DCS investigation, etc. Then opposing counsel produces the disclosure. It's two 5-minute-long videos filmed by the mother on a cell phone while the kid was in the bath. It went something like this: mom who told you to stick things in your butt. Child grandfather's full name, M. Who is grandfather's full name? C, I don't know. M is grandma? C, no. M, grandpa? C, no. List of about 5 other people. Is someone at school? C, yeah. Video cuts for 5 minutes. M, who told you to put things in your butt? C, my grandfather's full name. I pointed out the leading questions and the timestamp, and mom was held in contempt for falsifying abuse allegations during a custody matter. Story 87. I got mugged once. They caught the guy, and I went to court to testify. As soon as I walked into the packed courtroom, the kid says I ain't never seen that dude in my life. The judge asked how he knew I was there to testify against him. Everyone laughed for about 30 seconds. It was glorious. Story 88. I had to finally log back in for this one. I was at a hearing just a few weeks ago in which plaintiff's counsel was trying to prove that, for purposes of jurisdiction, his client neither resided in nor had any contact with the state of Georgia. He submitted an affidavit from his client, signed the previous week, which stated that she had not even been in Georgia in the last year. Halfway through the hearing, I pointed out to the judge that the affidavit had been notarized in Fulton County, Georgia. We all had a good laugh, even opposing counsel, and the court rejected his argument for that and other reasons. Story 89. I was a public defender, and I had a DUI trial where my client allegedly refused the chemical test. At closing, the DA literally said, "I wish we had more evidence in this case." In a grand gesture that I was sure the jury saw, I crumpled up my notes and threw them away. 20 minutes of deliberation and NG. Story 90. Not opposing counsel, but my own client. I was doing a routine traffic ticket that was involved in a minor accident. My client was charged with being the cause. Since there were no injuries, the case was handled by a magistrate, not really a judge usually. I told him, look, the police office hasn't shown up. The only witness who showed up is a passenger in the other car who wasn't paying attention. I know you claim this wasn't your fault, but we don't need that argument today. All you need to do is shut the up. We go through the basic motions and the other witness is like, I don't know what happened. I didn't see it. All I know is there was an accident. I know we were rear-ended. Great, case closed. The judge says, well, in light of that. And he cuts her off and says, Your Honor, I have pictures. So to recap: 1. No one could put him at the scene of the accident. 2. No one saw what happened. 3. If you rear-end someone in my state, you are presumed at fault unless you can show they backed into you or cut you off. Which pictures of my clients with the front of his car damaged and their car with the back damaged don't do. The magistrate looks at my client and says, did you hire an attorney for a reason? Yes. And did your attorney give you any instructions about how to act today? He did. Without telling me what those instructions were, did you follow them? No. Okay, well, in light of this, I'm upholding the ticket. As we were walking out, he asked me, was that my fault? Story 91. Not a lawyer. My in-laws were in an accident once in Texas. They were waiting at a red light when a car came slamming into the rear of their car, totaling both vehicles. The in-laws' car was hit so hard the seats snapped. Anyway, they had this little Mexican lawyer who had his own tiny practice to go up against a huge behemoth of a law firm representing the other guy's insurance. So they finally get to trial, and the big law firm gets the photographs of the car at the scene tossed and not admitted into evidence for whatever reason. So my mother-in-law gets on the stand, and her lawyer asks her to describe the scene, which she promptly begins to do. Now let me tell you something about my mother-in-law. She's not a softie by any means. She's a single mom survivor from the New Haven projects in the 60s. So she goes on to describe things from her perspective, which was probably embellished to some degree. Something like the back tire was touching the steering wheel, etc., etc. The big law firm's attorneys jump up with objections. The judge basically told them that since they had the photographic evidence thrown out, she gets to describe it. She won. Story 92. School lawyer here. Had a student claim she aggravated an injury at school because the teacher hadn't followed the doctor's orders. When the doctor got on the stand, he testified that a few weeks after filling out the school form which we had, he'd spoken to the mom on the phone and ordered some changes to the student's routine. Then Mom testified that she'd emailed this new info to the teacher, except we had all the emails, and none of them said anything about the doctor. Mom backtracked and said she must have forgotten because she'd been busy at work. And then, at closing argument, the family's attorney explained to the jury that schools are subject to a heightened standard willful and wanton, not negligence, and so it was their job to determine whether the school had disregarded a known danger. Naturally, we argued that the school couldn't well disregard a known danger if no one had ever told them about the new routine in the first place. The jury agreed. Story 93. Not a lawyer. My wife got hit by a drunk driving teenager years ago. Parents have and friends with the cops, so they get it hidden that their daughter was super drunk, she couldn't even stand up according to some nurses who lived across the street and responded right away. Their insurance refuses to pay value evidence. Wife tells lawyer to take it to court. In deposition, the teenager freely admits she was drinking, says it totally changed her life. She couldn't believe she almost killed someone. She's never touched a drop since and really sorry for all of this that her parents have done. Insurance company lawyer looks at wife's lawyer and says, "We will give you a call tomorrow." Story 94. Public defender here. I represent quite a few clients who routinely gift wrap convictions for the state. I have a client right now who was pulled over for running a stop sign. The cop is literally holding her driver's license with her current address on it. On the side of the road, she asks the cop, "Are you going to ask to search my car?" And the cop says, "Yeah, sure if you don't mind." And she guns it. I asked the cop in a deposition when she drove off. Was it at a somewhat reasonable speed, or was it like a Dukes of Hazzard, gravel-spitting peel-out? And he laughed and said, "Oh yeah, Dukes of Hazzard style." I didn't chase her because I was holding her license, so I just drove to her house and arrested her there. Story 95. Not a lawyer, and it wasn't a lawyer that proved my case for me. But several years ago, I was at a college football game. 100,000 people partying and drinking in the streets. I was walking along with a buddy. We both had beers, and as we crossed the street, this woman cop told me to pour it out. I didn't understand why, since everyone else was drinking and I was the only one she called out. Didn't even say anything to my friend who was also drinking a beer. I crossed the street, took one last swig and threw the rest away. Probably a half a beer. I continue on my way, get about half a mile down the street, and this male cop comes up to me. He asks my name, then asks if I heard what the cop said to me down the road. I assumed they thought I was underage, and I was about 25 or so pretty blasé about the whole thing. I told him I was of age and answered yeah. She said, "If that's beer in your cup, pour it out." He then asked what I did, and I said I poured it out. "No, you didn't. You drank it," he said. And he immediately grabs my hand and zip ties me and throws me in this van. I was pissed off and sat in this van for an hour while I watched a parade of people walk by, all with beers in their hand. Anyway, I was given an open container charge, so a month later I have to drive 300 miles to fight this thing. I show up in court and there's this crotchety old judge presiding over this stuff. There was about 200 college kids packed into the courtroom, and right off the bat, I knew I was in trouble. The judge would ask some kid if he was pleading guilty or innocent. The kid would say innocent, the judge would ask what happened. The kid would start with, "Well, I was." And before they could even get out another word, the judge would pronounce him guilty, bang his gavel, and move on to the next one. So he finally gets to me, and the judge asks me if I'm guilty or innocent. I told him I wasn't sure. I think that caught the judge's attention, as he asked what that meant. I told him that I did have a beer, but that I'd done nothing wrong. He asks me to relay my story, so I tell him. He asks the arresting officer the man if he saw me drink the beer, and the cop says no. I just heard over the radio to look for this guy, and I saw him, so I grabbed him. He asks the woman cop why she didn't stop me herself. She said that I had already walked by and was too far into the crowd for her to stop me. So he was already past you. All you saw was his back? She replied yes, that I was already too far away into the crowd. The judge says there's no way you could be sure he chugged the beer if he was so far away that you couldn't catch up to him. He looks at the ticket and goes, "So, this was a game day. Were there other people drinking?" And the cops both say yes. He asks how many other people were arrested for open container, and they said none. He asks the courtroom full of other kids if any of them had gotten an open container on that day, and not a person said anything. At that point, the judge tells both cops to step into his office and for me to wait there. I wait around for a few minutes and they all come back. The judge tells me, and the whole courtroom, that it's obvious they didn't see what they thought they'd seen, that he couldn't believe he'd been singled out, he'd spoken to both officers, and he could guarantee it'd never happen again. Then he apologized on behalf of the town, told me he was sorry they'd wasted my day, and told me I was free to leave. It was awesome. Story 96. Yes. I used to videotape depositions many years ago. Client was suing insurance company for 2 years back wages after an injury. Conversation went like this. Insurance lawyer. It says you're asking for $120,000 for 2 years back pay. Client, yup. $60,000 per year IL. Well, we have your previous tax returns. Those are only $30,000 per year. Client's lawyer ID advise you to. Client, I know. I only put that on my tax form. I actually make much more. The insurance lawyer very calmly asked to go off the record. He said, well, your client just admitted to tax fraud on video. This case is pretty much done. Now, and I don't want to put you out, but I need to figure out whether or not I'm legally compelled to tell the judge or IRS about this. Well, be in touch. TLDR guy, suing for back wages admitted to tax fraud on video deposition. Story 97. I've posted this once before, but I was in traffic court one day, and there was a taxi driver fighting a ticket he got for running a red light. He was traveling westbound first thing in the morning, and his defense was that the sun was right behind the traffic light, so he was having trouble seeing it and believed it to be green. Story 98. Yet another IANAL, but told to me by a friend who experienced this while doing her internship at the court. First of all, this is about Austrian law, and I try to explain it as good as I can. But when it comes to legal terms, my English sucks. Here in Austria, we have a rule in law which is called culpa in contrahendo, which simply means when you are about to close a contract, you do have some duties that you must not violate, so that even if the contract will not be finished, but you do not obey these duties, you are still viable for damages resulting out of this behavior. So here in Austria, we have two different types of claims for damages. Ex contracto means from breaching of a contract, and ex delicto means from breaking a law. So if you want to claim damages, you must prove that the other person broke a contract or broke a law which resulted in damages for you. So for you to be able to claim ex contracto claims, you have to have a contract. OR proved that the partner broke his culpa in contrahendo shorten end CIC duties leading to this contract. This for the theory of this case. The case Icy Day here in Austria. A woman enters a shop and slips on the stairs, hurting her ankle. There is no law that you have to permanently remove the ice from the entrance stairs, though, so no ex delicto. But the access to the shop being without danger is one of the CIC duties of a business owner, and therefore the woman sues the shop for her broken ankle. Please bear in mind that the sums for claimable damages here in Austria are really low compared to the US, and she would have only gotten maybe $1,000 to $2,000 from it, depending on how long she has been in pain. Civil courts here in Austria have very much interest in solving these cases by getting an agreement among the parties. So the business owner a clothes shop offers her don't know the exact amount something along 500 in vouchers to settle all this. To this, the woman just replies, "What should I do with these? I never buy anything at this shop anyways." And this was the exact moment she lost the case. She just said she never intended to buy anything there, so no possible contract, therefore no culpa in contrahendo for the shop owner. She left the courtroom with nothing but the bills for both lawyers. Story 99. Not a lawyer, but this is a story about my uncle, and it's quite brilliant. My uncle has been a lifelong videographer and still works to this day as a news photographer. During the early to late 90s, he stopped shooting news and started shooting freelance. This was before everyone and their moms had a camera editing software whatnot. Eventually, he became a sought-after photographer. In the 80s, when he was working as a news photographer, he met and married a reporter news anchor, of which he would go on to have 2 children with. After leaving the news business to freelance, he decided to start a video editing business with his wife. That went extremely well for a while, and they were making money hand over fist. He would be asked to shoot for channels such as Food Network and HGTV, DIY, etc., and then edit it into the show. She would work as the middlewoman for his clients and as bookkeeper. Eventually, she would turn out to be a secret substance abuser and adulterer, and their marriage ended in divorce. At this point, my uncle was making a couple $100,000 a year with their business. She decided to sue him for alimony, mostly because he was worth a good chunk of change, but also because she helped him build his business. Her demands were ridiculous. something like 75 of the business for the next so many years or something crazy. My uncle's lawyer was afraid she was going to win because she had played such a big role in building the biz. Fast forward to court day, her lawyer stands in front of the judge and lists off what she wants in the divorce. Once he is finished, it's my uncle's turn. He blindsides her and offers to give her 100 of the business. The judge and both lawyers are confused and ask him if he is sure. Without him shooting and editing, there is no business. So basically, she would be left with a lot less than she asking for by asking for X amount of profits. The judge reasoned that his offer was fair and that she could take it or leave it. She was pissed, her lawyer was pissed, and she ended up getting nothing, haha. TLDR. My uncle started a biz with his wife. She turned into a cheating drug addict. Divorce. She wanted X% of profits from biz in divorce. He offers her the entire business, total awesome move. He is a photogenitor, so she can't do with biz because she isn't a photogenitor. She gets nothing. Story 100. I had an opposing counsel who wrote in his defense that he admitted to my entire statement of claim. So that went well. We kind of concluded that it was Christmas Eve and the fool probably got someone else to do it for him. But it gave me hope that if he could be a lawyer, so could I. Story 101 IANAL, but a cop. Had a case where the defendant got drunk, assaulted his baby mama, poured a liquor bottle on a 3-year-old like he was in a rap video, then grabbed a 1-week-old infant and ran across the apartment complex with her like a football. Among other things, he was charged with child endangerment. The defense seized upon the language in the law that child endangerment only applies to the child's parent guardian. Now, both defendant and baby mama claimed the infant was their child in common on scene, but of course in court the defendant denies paternity, and we don't have a paternity test to prove it. Anyway, this all came up in pretrial hearings, and after the one where the paternity issue was raised, the prosecutor pulled the defense attorney aside and said that if they were willing to provide an affidavit denying paternity, the prosecution would agree to it, drop the endangerment charge, and direct indict on felony kidnapping. The look on the defense attorney's face was priceless, and the defendant shortly accepted a plea deal. Story 102. Not a lawyer, but a case I got to witness. I work in IT, and a gentleman came to our office asking if we had experience working with security camera systems. We do. He was being convicted of assaulting an officer while in prison because the officer said the defendant had too many magazines in his room. The defendant threw the magazines at the officer's feet and walked away. Disrespectful, but not assault. The officer then tased and cuffed the defendant and claimed he was kicked by the defendant. This led to a confrontation, but they had conveniently lost the security footage. He wanted me to come in as an expert in the field and explain how that doesn't just happen. I arrived at the court and the man's public attorney raised a bunch of questions about have I ever worked on a prison security system or even on the particular prison security cameras before. I had not, so I was out. But since I was there and they guy seemed nice, I sat in on the trial. During the trial, the prosecutor said, "We found a footage, however there seems to be some errors with the files as the visuals are blurry, but you can still hear the audio." When they played the footage, you could hear muffled yelling and someone saying, "Stop resisting." And he just kicked me. Keep in mind this footage was supposed to be 4 to 6 months old. The date stamp on the video evidence. 1 week prior. He was found innocent. Not sure if he sued back or anything. Story 103. Not a lawyer, but I was crashed into about 10 years ago and was given a hire car by an accidents company. Had it for about a month and a half because the insurance of the guy who crashed into me were really incompetent. They kept making things take as long as they could, and then eventually when they sent me the check, there was some issue with it which took another 2 weeks to sort. All along, the hire car charges were mounting. They eventually came in at a few thousand for a hire car worth not much more. A year or so later, they took me to court because of the hire car charges. They said that the hire car charges were crazy, they were to be fair, and that they were 6 times what my totaled car was worth they were, and that I should have had been given a car worth the same as mine to loan whilst they were sorting it all out. Apparently, the law says that the victim shouldn't I be in a worse or better state whilst the claim is in progress. I was. Their argument was starting to scare me a little bit as they were asking me stuff like, was it a better car than yours? Was it newer? Was the AC better? On, and all I could do was agree. I wasn't going to lie under oath. The judge stopped them before they had finished questioning me and asked them if they knew a rental car company that had 15-year-old Rovers. then closed the proceedings and apologized to me that they had wasted more of my time. Story 104. My buddy's a lawyer. It wasn't opposing counsel, but it was a technicality that came out in a deposition. IANAL, so forgive me for not getting some things perfectly right. I'll make this quick with bullet points. Man high fives other man. Man happily receives high five and falls off his bar stool. Hurts his shoulder. Man waits to sue. Man decides to sue other man, his buddy. My friend represents the defendant. Depositions ensue. There was a statute of limitations on seeking damages based on intent. Basically, if it was negligence, the limitation was longer than if it was done out of malice. My buddy, through his line of questioning, asked the man, "And so you believe that this man meant you harm when he, as you say, aggressively high-fived you?" The plaintiff responded with a yes. Done. If he had filed sooner, he might have had a case. But since he believed the intent to harm was there, he missed out. Story 105. Former prosecutor in the UK here. Defendant had not attended community service and went to trial stating he had a valid reason not to attend. Usually we would accept doctor's notes, proof of hospital admission, evidence of travel disruption, but he had none of this. He told his solicitor he was unwell and his note was lost in the post. I began cross-examination by asking if he attended on the date. No, I didn't. Did he have a transport issue? No. Was he unwell? No. Am fit as a fiddle. I looked at his solicitor, a friend of mine, outside court, and he buried his head in his hands. So why didn't you attend? Oh, I was meant to say I was sick, wasn't I? Quickest trial I ever won. Story 106. Am not a lawyer, but I served on a jury once. The prosecutor was young. Everything he presented made the defendant's case stronger and stronger. The defender lawyer looked very confused because he kept stealing her thunder. It was weird. Story 107. Not a lawyer, but pretty proud of myself for this. Years ago in my late teens, early 20s, I had just gotten my driver's license. I accidentally bumped into a parked car while reversing out of a parking spot. Now I was reversing at a very, very slow speed, so while I definitely made contact bumper to bumper, I did not see any damage on either vehicle. But just to be sure, I wrote down my name and mobile number on a piece of paper saying I tapped your bumper while reversing, did not see any damage, but feel free to call me if anything is wrong for you, and stuck it under the wipers. As I had an appointment, I did this and drove off. A week or so later, I get a call from the local police station about an accident. So I go there and tell them exactly what happened, and that I had left my personal information on the other vehicle. The cop says, "Don't worry about it. There was no bodily harm, etc. Probably let the insurance companies take care of it." Another month passes, I get a call from the police again, saying they had a bailiff's letter addressed to me at their office. So I go to pick it up, return home, and upon reading said letter, it stated that I had been summoned to appear in court in regards to this accident. The date at which my hearing was to be held had already passed by a week. So I find out that I had been convicted of paying upwards of $1,600 in damages and had my license suspended for 3 weeks and had to take the driver's license test again because the accident was considered a hit and run. Apparently, some old woman had seen the whole thing, had written down my license plate number, and then had informed the owner upon return to his vehicle of what had happened and that he had to press charges. The owner of the vehicle was an older gentleman, and while he didn't see any damage, he did go to the cops to report it. So I am outraged. The cops had waited far too long to inform me, resulting in my absence from the hearing, and I had left my personal information on the vehicle. The vehicle was registered in my father's name, by the by. So my insurance kicks in, my lawyer demanded a resit, and we got it. A week or two later, I am in the courthouse, first time ever with my lawyer, and we wait until my name is called. My name is called, and the judge tells me to step forward. He asked me to explain what happened. I explained them patiently that one. I did in fact hit the gentleman's car, but at such a low speed, no visible damage was done. 2. I had left my name, mobile number, and explanation of what had happened on the gentleman's windshield wipers in case he felt wronged. 3. I had left the scene due to an important appointment and the fact that I didn't see any damage nor had hit a person or anything. 4. I found it strange that while they claimed they did not find the note containing my personal information and only had the license plate to go on, all of the letters were sent to ME, while if they really only had the car's info, my father would have been the one summoned. The car was registered under my father's name, and I was a designated driver for it. 5. I had visited the gentleman who could not be present during the hearing due to his wife being very ill. He had written a letter stating that indeed he did not find any damage done to the car and did not want to press charges, but felt pressured by the woman surveilling the neighborhood. All of this took 5 minutes to say. When I was finished, the judge smiled and said, "Young man, you should become a lawyer," and proceeded to expunge me of all punishment I had received the last time, with only a warning that if anything similar happens within a year, it will be considered during that trial. I had to pay a 20 fine because I did indeed hit a vehicle, but I was fine with that rather than paying 80 times that amount due to gross neglect by whatever sent me that letter. Story 108. Okay, sorry for another. This doesn't exactly answer your question, but anyways. I'm a licensed lawyer now, but interned as a public defender during law school and had a limited license to do practice for public interest work. I had a trial for misdemeanor assault, and the guy I was defending fired me to represent himself, but my office had me appear in court as his advisor. During the trial, he gave narrative testimony because you can't direct exam yourself without it looking ridiculous. He pretty much admitted to every element of assault while testifying. The prosecutor's closing entire argument to the jury was he did it, he admitted it, the evidence shows he did it, go convict him. He was convicted of the assault but not the disorderly conduct because the jury couldn't find he was ordered to desist by police and disobeyed. Story 109. I was deposing the defendant neurosurgeon in a malpractice trial. The accusation was essentially that he removed an insufficient amount of disc material that was pressing on our client's spinal cord, causing permanent damage. We put the pre-op MRI up on the screen and had him describe what parts of the spine needed operation and why. Then we put up the post-op MRI to have him explain what he did during the surgery. He said, "This looks like the same MRI. Are you sure you put up the post-op images? Because these look the same." The case settled shortly thereafter. Story 110. Yes. It was a 3-day jury trial in family court. We represented the dad. The mom had no reason at all to file for child support. They had literally had a 50-50 custody agreement between themselves since the babies were 9 months old. The social worker recommended they continue joint custody and had much better things to say about the dad. They tried to concoct some kind of allegations, which we kept out, so they really had nothing at trial to go with. What they came up with were these weird allegations that the kids were dangerously asthmatic and the father didn't take it seriously. While it's true that the kids had asthma, they were arguing that they needed special equipment. They produced no medical records or experts, but that was basically their whole argument. The kids were dangerously asthmatic, and the father was neglectful. We rebutted the argument as best we could for an issue that had never come up before. We asked every witness about these asthma issues, and they all said they'd never heard of it before. We also pointed out that the mom's mother, who cared for the kids nearly every day on Mom's Days, was a smoker. I think we had already won the trial at this point, but what they did next was like the nail in the coffin. They called the grandmother as a rebuttal witness. She was their last witness. They called her to the stand so she could testify that she never smoked inside when the kids were home and that her smoking wouldn't affect their serious asthma. That was their only purpose for putting her on the stand. As soon as she sat down, she leaned forward and cleared her throat into the microphone. It sounded like this: EHXXMKJRAUGHKEKXXLTHFKEHHHH. She had a voice like the evil mom from the Goonies. It was over before she said a word. Jury verdict for us came back after half an hour. Story 111 IANAL. But I was sitting on a jury when a genius who decided to defend himself asked the wrong jury selection question. He was a large man who had been cut off on the highway by a not-too-bright, small teenage girl who had been talking on her cell phone. In his road rage, he followed her to a parking lot, and for reasons I don't understand, the teenager got out of her car to meet him face-to-face. Predictably, the squabble escalated, and he hit her. This wasn't a slap, or a gentle tap. This was full-on and closed-fisted. It resulted in several bones and teeth being broken in her face, lots of bruising, and a hospital stay. There were pictures. It was brutal. This brilliant man decided he didn't need a defense lawyer, so when it became time for his side to ask the jury selection questions, he pulled out an organized folder and asked the first question on his well-planned docket, which I'm sure he'd given a lot of careful thought to. Don't you think some women deserve to get hit? The judge literally face-palmed and advised that the defendant take his last gracious chance to lawyer up. The judge also asked that the jury to forget he asked that question. I was dismissed due to similarities in the case with a crime I was the victim of, so I don't know what inevitably led to his guilty verdict. I can take a guess. The entire jury had laughed, gasped, groaned when he'd asked that question, and I was the final alternate released, so I'm sure they weren't entirely able to stricken his question from memory as the judge had requested. Story 112. Obligatory IANAL. My divorce took 7 years to complete. It started when my ex moved out in the middle of the night to teach me a lesson, so when my kids woke up the next morning, their mom was just gone. I filed at the end of 3 months. When I served the divorce papers to the ex, she accused my brother of molesting my 8-year-old daughter because he told her she should get spanked for some stupid thing she did. I don't remember what. She then took the children on a picnic, but called me at midnight to let me know she had taken them and moved to a neighboring state. I was able to get them back after 6 months solely because she had taken them to another state without notifying the court. She changed lawyers when they refused to do any more work until she paid them. She somehow got the court changed multiple times over the course of this 7-year period. She did a bunch of other things that the court knew about, and a lot more it didn't. The last court she got transferred to, completely on her side's initiative, turned out to be my lawyer's roommate in college. Their wives were roommates at the same college, and they had been friends for decades. They joked with each other and made plans for the weekend at the start of the first appearance in that court, and the ex's attorney didn't request a recusal. Even with all this, when it came to the final decision, the judge was clearly about to rule in favor of full custody for my ex. My lawyer had prepared me and cautioned me not to make a scene of any kind when I lost because future court appearances regarding my children would be affected. So, I was so focused on maintaining composure that I didn't hear what my ex said when the judge says, "What? You did what?" I look over and her attorney has his head in his hands, and she's standing there telling the judge when she first accused my brother, she had to go to 3 different judges before she found one who would accept her testimony and issue a restraining order against my brother. Apparently, from the court's point of view, all of my actions were colored by this accusation against my brother and my insistence that my brother had done nothing wrong. The ex's comments at this point completely turned the court's opinion upside down. The judge ruled in my favor, and I got full custody of my children. Story 113. Not a lawyer, but had a friend in this situation. My buddy was in a car accident with a few other cars. Everyone with injuries filed a claim with the person at fault for a $25,000 policy. Split so many ways, nobody was going to get a ton of money, but need the claim to go through so they could follow up with their own policies. Right as the claim was about to close, one guy jumped in wanting the entire payout for injuries sustained in the crash. The thing was that this guy's car didn't even get hit. My buddy's attorney sent a memo over to this guy's lawyer basically asking if the dude was full of out not. This guy's lawyer sent his full medical records showing that the health issues the guy had were pre-existing and he was just trying to get his upcoming surgery paid for. His lawyer threw him under the bus and he had to drop the claim. Story 114. Not a lawyer, but case that I won. I had worked as a leasing consultant for a very well-known apartment rental company 12 years ago. My schedule start time changed daily weekly, and it was not uncommon to work 9 days in a row, so it could be exhausting. The office switched to using a fingerprint punch-in clock when you start your shift, and if you missed it, you had to fill out a time card sheet. So I missed a punch-in one morning and filled out a sheet a few days later. I wrote my start time as 800, but it was really 900. So the assistant manager called me asking about it the day before we put in our time cards for pay, and I said, "My mistake, it was in fact 9. Let me know if you need me to come into the office and correct it." She said no problem. 2 hours later, she calls me again, but sounds strange and asks why I wrote down 800. I said I was confused because the rest of the week had been 800, but again, no problem if you need me to correct. I was told no, that is fine. Turns out the manager was on the other line who hated me and they tried to get me to say something that would fire me. I did not, however, I was fired for trying to steal 1 hour of pay. After I got fired, I filed for unemployment and actually got it, because when the unemployment office called the manager to get her story, she never returned the call. Jumped to me at a new job 2 months later, and I get a court notice that my old boss and company is taking me to unemployment insurance court because they want to dispute the 1 month I collected unemployment. So I go and they have a corporate lawyer, the HR person, the assistant manager, and manager against me. We sit in front of a judge who hears our case, and I provide my side of the story, showing how much the start times change, etc. They provide their side, and the judge goes, okay, so the employee was fired for taking 1 extra hour of pay. I interject and say, Your Honor, I never received the pay for that hour. He asks, what do I mean? I tell him the problem was caught before the timesheets went in. He rubs his face and says, so why are we even here? My old boss says because he tried to steal an hour. The judge goes, I heard enough. You will get my judgment via letter. This session is over. He ruled in my favor, so I got to keep that 1 month of pay and the money they wasted on the lawyer, the HR women, and getting people to cover that property while the managers had to go to court probably cost more than the money they were fighting me for. D-ha-ha them. Story 115. Obligatory not a lawyer here. But I was being sued and watched my lawyer help themselves lose the case. I caused an accident in 2016. I got bored driving the same route day in and day out, and daydreamed out my car window while going 60 and didn't notice the slowdown in front of me until it was too late to fully stop. I did stop most of the way. They estimate I was going definitely less than 20 miles per hour and possibly under 10 miles per hour when I did hit the lady in front of me. Overall, I did more damage to my own vehicle than to hers. We pulled off the road and we checked on each other. Everyone was fine. Exchanged insurance. I had cut rate insurance at the time with minimal coverage, so I was going to be coming out of pocket on my own damages, and she had bigger brand name insurance, like a real adult. We waited 45 minutes for the cops to come, and then filed the police report. Whereupon I got a ticket, which was super cool icing on a cake. I call my insurance company and tell them about the accident. They say they will handle it. I check BBB for their rating, and it suddenly occurs to me that my choice in insurance coverage, while cheap, might end up being really annoying. They appear to have a habit of fighting every single claim. So I get my car repaired, the lady gets her car repaired, all is well, and then the sheriff shows up at my door with a summons to a panel of judges. I say to myself, good Lord, 3 months have gone by. How could this still be a going concern? I see the amount I am being sued for, a bit over $3,000 in damages, and am just flummoxed. How can my company be contesting that paltry sum? No medical expenses, just fixing the bodywork and the bumper and whatnot. I call my company and they say a lawyer will contact me shortly. They call later and say that if I don't show up, I'll have to pay the expenses. And now I know the game. They just want me to flake out and leave me with the bill. So I'm pissed at the stupidity of the situation, but resolved to do everything they ask. Around this time, I got new insurance. The same brand as the lady I hit, as it turns out. The date for the panel of judges comes. I have a lawyer, the lady I hit has a lawyer. We go over the basics of the case with the judges, and then they are left to decide whether my company will pay the whole amount or just some of the amount. Apparently, the judges ruled in the favor of the injured party. I know this because I get another summons to court for an actual jury trial, as my shitty ex-insurance company is appealing the decision. So it is now 1 year and 3 months since the actual accident, and I am in court again, this time with a different lawyer. She was young, very young, working as a lawyer for 8 months young. I don't have much confidence in our case to begin with, what with me hitting the lady and admitting it and causing all the reasonably priced damage. The other insurance company's lawyer comes up and offers a settlement requesting 75% of the original asking amount. My lawyer tries to reach our insurance company's claims adjuster. He is unreachable because he doesn't own a cell phone. The insurance adjuster shows up and is exactly the type of person who you would expect to not have a cell phone in 2017. A short, mustachioed, and balding older man with a bad leg whose demeanor I would describe only as crotchety. He arrived and grumbles, well, I'm here, we might as well do this. Gesturing to me, he says, not like you care. Of course I don't want to be here, I scream internally. We start the trial, all the jurors get selected, it's been hours. It's kinda cool to see the system functioning, but it is boring. We get into the meat of the trial, witnesses. After my very short time on the stand, my lawyer, ML. Their lawyer, TL me ML. How hard did you hit Mrs. Lady? Me. Not an expert, but I'd guess between 10 to 20 miles per hour difference between our two vehicles' speeds. ML. That is all. TL. You caused this accident? Me, I did. TL. What led to the accident? Me, lack of attention. I looked away for a few seconds and didn't track what was happening up ahead. TL. Thank you. That is all. My lawyer then called our side's insurance adjuster, and the other lawyer takes him apart. He's clearly not fully up on damage that was done to the vehicle, never actually inspected it. The other side's whole case is based on the fact that our side's estimates of the damage was just that, an estimate, not based on actually removing the bumper and examining the full extent of the damage. Our side kept trying to say that the estimate was enough, but that's just pants on head retarded. Their lawyer then calls their insurance adjuster and they go over the damage and the reports from the garage that worked on the vehicle. And here comes my favorite part. On cross-examination, my lawyer asks the enemy insurance adjuster about his experience with my shitty insurance company. He doesn't say much, just that he is familiar with them as an organization. Their lawyer seizes upon that and asks a follow-up question. He inquires about the nature of that relationship. He asks if there is an industry term for my insurance company. My lawyer objects, overruled by the judge. Their lawyer is just looking to expand on my lawyer's previously asked question. Their insurance adjuster on the record gets to state that my insurance company is referred to as a substandard and shoddy insurance company. The jury looks kind of shocked. I was grinning. They let me go while the jury was deliberating, but I'm pretty sure they were going to come back and find entirely against my insurance company. I like to think so, at least. It is delicious to me for them to expend all this effort and then still have to pay everything. They even had a pretty solid offer where they wouldn't have had to pay for everything. What a company. Also, as I was leaving the other side's, lawyer thanked me for being honest, which I found confusing. Apparently, people make up all the time once they get into court. We chuckled together over the substandard comment that got entered into the record. Story 116. IAAL. But this case pertains to a trial in which my father participated as a representative of one of the oil companies. During the 1978-79 Iranian Revolution, where the Shah was deposed in favor of the current ruling Council of Clerics, the Iranians seized most of the assets of the Western oil companies and nationalized them. The oil companies sued Iran in the World Court for restitution. There were 3 panel tribunals set up to adjudicate the cases. One of the judges was pro-Iran, one was pro-American, and the third was a neutral party. In this case, the neutral judge was a very well-respected older gentleman. I believe he was Dutch, if memory serves. Anyway, the Iranian delegation caught him in the halls after one of the trial days and beat the out of him, as in it took him months to recover. In general, if you are undergoing arbitration with a 3-man panel and there is a neutral third party, it is probably best not to beat the out of him. Iran had to pay a lot of money to the Western oil companies. Story 117. I am not a lawyer, but I had to sue a tenant. Basically, I said if he vacated the premises by a certain date, I didn't care about the back rent that was owed. He did not vacate the property, so I took him to court. His defense was that if he moved, I wouldn't sue. He even brought a witness to discredit my version of our conversation. Except the witness corroborated my version of the conversation, to the word. The court clerk was astonished, and I won the judgment. Still haven't been paid and probably won't, but just hearing his witness confirm my version was satisfaction enough. Story 118. Kind of related story, my stepdad SD owns a house building company. Last year, he was building a house for this cheap CB. CB was trying to save some money by finding errors with the work my stepdad did. So one day after a very heavy rainfall, he finds the floor of his basement wet. He told my stepdad that must have been because the basement walls are faulty and he is not going to pay for them. SD tells him it is because the house doesn't have a roof yet and CB will be paying for the walls. But CB is insisting that the walls are faulty and calls his friend, who works at a ready-to-use concrete basement wall company. So this friend looks at the basement walls and tells SD that yup, these walls must be faulty. The friend didn't realize, though, that the walls were made by the company he is employed. SD calls said company asking why they got a representative running around telling him that the walls they sold to him are. Company looks into that, finds no fault at the walls. The water is gone by now, because it was rainwater and it's 3 days later now, and goes ahead and fires the friend who worked for the company for over 20 years because he was lying to the customers and telling them their own walls were. Story 119. I am in my last year of law school, so not a lawyer quite yet. However, I've worked with lawyers for several years. The best way to win is when the opposing counsel does not know when to shut up. This past year, I did criminal defense appellate work, and the office advised not to use the entire time given during an oral argument. Say your piece and sit down. Presenting at oral argument usually means that you have done a lot of case research and know cases that are either good for you or bad for you. It's especially important to know a case that speaks directly to the issue you are presenting and whether the judges in that case went your way or the opposite way. If it's the opposite way, you better have a good argument to tell the judges why your case is different. We had an attorney show us video of a DA's oral argument before our state Supreme Court where he just kept talking. Talked so much that he talked around his issue, and the justices kept poking holes in his argument. At one point, a justice asked him about the one case that would have won his case for him. Literally, all the DA needed to do to win was stand up, point to this case, and sit down. But then he admitted that he hadn't even read the case. Our attorney didn't even use his rebuttal time because the DA had already lost the case. The DA later sent out an email to his entire office that he would never do oral arguments again. Story 120. Long story short, I broke up with my GF shortly after moving into a new house with her, and she went behind my back to have my name removed from the lease before we even moved in and didn't tell me until 4 days after moving in. I moved out ASAP, and then she was evicted a few months later and left the home a huge mess. We were both sued for back rent and cleaning repair expenses. I got her to cooperate with me and provide text message correspondences between herself and the landlord, where they set up a meeting to remove my name from the lease without my knowledge. We get to court and are called in front of the judge. Neither of us have a lawyer, but the landlord does. When it's my turn to speak, I tell the judge I was never on the lease while I was living in the home and that I can prove it. The landlord's lawyer asks to speak with me privately, and I show him the text message transcripts, and he said, well, my client is a lying sack of. I guess you're off the hook. We go back in front of the judge, and the lawyer states that he is dropping the claim against me, and the judge asks why. And he said something like, in light of new evidence. And I added, I believe your words were my client is a lying sack of. The look on both the landlord and her lawyer's face was priceless. I still feel bad for the landlord because my ex did trash that house and not pay a dime in rent for 3 months after I moved out. But she knew getting the money from my ex would be like bleeding a stone, so she lied about removing me from the lease because she knew I made good money. Oh, and if you want more juicy details, my ex's plan was to get me to pay the first-last security on the place, about $4,000 worth, move her stuff in for her, then kick me out and have her new boyfriend move in. That didn't work out, and she ended up living in a complete hole for a while after she got evicted, and now she's still unemployed and a welfare case. Story 121. I represent low-income tenants with housing disputes, mainly eviction defense. Easiest case I ever won was when landlord wrote us a letter admitting that they rejected the client's rent. Then they sued to evict for non-payment of rent. I've learned to send short but polite demand letters to landlords before the case goes to court, asking them to drop the eviction. It's a lost cause, but they will often send completely unhinged letters back that hurt their own cases. In this case, landlord admitted that client tried to pay rent the day that it was due when landlord was out of the office. But that client should have paid early because landlord's life doesn't revolve around tenant. Story 122. My dad was in court for a vehicle collision. He won on the spot when the plaintiff was asked to draw the vehicles on the road, and they drew their car over the line. Story 123. I am not a lawyer, but was on a jury where this more or less happened. It was a DUI case where the defense attorney was very obviously going to go for an extenuating circumstances plea, whatever that is actually called. In the opening statements, the defense attorney essentially said, did he drive while intoxicated? Yes. Should he have been behind the wheel? No. Was he kind of a bad guy? Yes. But you will understand that he had no other choice. However, the judge did not let him use that argument because during testimony, there was never any proof that established that he was in fear for his or his wife's life. The conditions for that kind of defense were never clear, so the judge literally had us as the jury decide did he drive a motor vehicle while intoxicated and did he swerve into oncoming traffic while intoxicated. Opening statement from the defense attorney and all testimony made it very clear that he was driving while intoxicated. So he was found guilty easily. We all sort of went into a room and were like, let's vote. Unanimous on both counts? We were like, do we need to do any kind of due diligence and discuss? It was an interesting experience, and the attorney was angry, sweating, red-faced, and was berated by the judge several times for acting inappropriately. Story 124. This is a Canadian colleague of mine, and it wasn't due to incompetence, but rather good ethics. In Canada, lawyers are also agents of the court, meaning they are expected to defend the truth as well as their client. During one hearing, she noticed that her client was lying during cross-examination, willfully going against what she had been told. This is tough, because she can't call out her client, which would destroy her client's credibility and tank her case. But she also had an obligation to the truth and to the court. So after the cross-examination was over, she pulled her client aside, instructed her to tell the truth, and then put her back on the stand and re-asked some of the questions, albeit phrased a bit nicer. The judge didn't notice what she had done, but the opposing counsel did, and respected her for it. When the judge got mad that she was reiterating questions, her opposing counsel actually stood up for her. The two sides ended up settling out of court somewhere in the middle. Story 125. Not a lawyer, but my dad owned a janitorial business when I was growing up, and got sued after he fired an employee for drinking on the job. She had been caught in the owner of a car dealership's office, blackout drunk after getting into his private stash. She was suing my dad for discrimination, because she was black and we aren't. So they are in court, and she takes the stand. My dad's lawyer is asking questions about the incident. And this takes place, Mom. You drank a fifth of XXX in the office on this date. Do you think this may have been the reason you were fired? Theft? I didn't drink a fifth! It was already 34 gone. Judge case dismissed. Story 126. This was not a trial, but a violation of probation hearing. My client was alleged to have violated a restraining order by coming within 100 yards of the victim. This should have been a misdemeanor trial, but the DA wanted the lower threshold. My client adamantly denied ever meeting up with the victim again. Fast forward to the trial, victim gets up in his stand and says that she went to my client's house one day after work. My client leans into me and says, "No, that didn't happen." Victim then further goes on to explain that she was at the house, but didn't let my client see her. She proceeds to wait an hour outside of his house because she sees his new girlfriend's car and is pissed. She then sees my client and his new GF get into the car and drive to my client's work. She follows them and proceeds to assault my client and his GF. No surprise, she gets arrested. I'm in shock at this point, and the DA is equally surprised too. She then says no, they never met up after. They never had. All of which were the allegations. At the end of the direct, I never crossed her because she gave me all I needed. Judge did not find that my client ever came within 100 yards of the victim voluntarily. Story 127. I represented the husband in a domestic violence case regarding an alleged argument that may or may not have escalated. In New Jersey, there is no right to discovery or requesting evidence prior to trial like in criminal, civil, or family cases. My client was angry over the divorce, which did not make him the best witness. However, the opposing counsel sent me the entire recording of the incident, over 25 minutes. The recording contradicted her client's story and showed my client did nothing wrong. Further, I played the recording after her client testified, so she lied in her testimony for hours prior to me playing it. No clue why she sent me the recording. I had no right to ask for it and didn't know it even existed until I got it from her. Story 128. I was defending a client in a contract litigation. In the first deposition of the case, the opposing counsel was taking the testimony of one of my client's employees. The first exhibit he marked was the contract at issue. A monster, 200-page document with lots of appendices. He hands me and the witness a copy. I start reviewing the exhibit, and I immediately notice that it is different from my copy of the contract. It has a lot of handwritten notes throughout. As I continue reviewing, I notice that the notes are from the opposing counsel, including things like "this clause hurts us, but I can still make a case." I stop the current question relating to the introduction of the contract and ask opposing counsel if we can go off the record to discuss the document. He says yes, his client is with him, and I don't want to embarrass him by saying, "Dude, you just handed me your annotated copy of the key legal document." So I say, "Counsel, it appears the copy of the exhibit you've handed me and my client is not a clean copy, but has handwritten notes." He takes a couple of moments and says, "You're right, let me clear this up on the record." At this point, I expect him to say something like, "You are correct, that was my mistake. Let me take those back as inadvertently disclosed and circulate clean copies." The court reporter puts us back on the record, and opposing counsel says, "I've been made aware that this version of the contract has some handwritten notes made by me. I want to be very clear that I am not waiving attorney-client privilege or attorney work product for any other document." It was all I could do to keep my mouth from dropping open. The entire case, That document was a goldmine, letting me see exactly which provisions he thought were most helpful and most harmful. And yeah, we won the case take nothing judgment. Story 129 NAL. But I had a friend move in at the end of college after a show of a breakup. She had dated and lived with this guy for about 5 years until they broke up. He has agreed to move his things into the garage of the house they rented until she moved out, then got super trashed with a friend and started threatening her with a gun, then broke the door in with her behind it. She locked herself in the bathroom and called 911. Well, CA is a zero-tolerance state when it comes to domestic violence, so they pressed charges for that. And terroristic threat note, guys, don't make threats with a loaded weapon to someone on a recorded call to 911. His counsel tried to argue that the domestic violence charges should be dropped as they had broken up, and he wasn't technically living there, are the time which, as I understand, wouldn't have held weight anyway as an argument. So my friend's lawyer said sure, but if they weren't living together, they were going to add burglary charges. He tried to backpedal that real fast. Story 130 NAL facts. Had a case against me where a lady's tire blew on the freeway and I hit her. Both went from around 70 to 45 miles per hour. That's where we agreed. A few months pass and I'm informed him being sued for medical expenses because my insurance wouldn't cover hers. Case takes 4 or 5 years to hit trial between the whole process and my college. Where it went wrong, lady was from Honduras, living in the States for over 10 years. She didn't want to speak English in court. The interpreter was one of the regulars on the circuit and had been doing it long enough that when my mom came in, they knew each other from my mom's days of insurance fraud investigation. I was first to take the stand. I was up for maybe 45 minutes. The jury was largely non-wire, relatively recent immigrants to the U.S., with the others as white women. Prosecution tried to accuse me of saying things I did not say by showing everyone my deposition and going over it with me line by line before asking again why I lied and didn't tell them that bit. To which I got to end on the satisfactory note of that wasn't what the question in my deposition asked. The lady was on stand for over 4 hours, mostly in cross. The lady gave her deposition in English for ease of my legal team. They gave her up until trial to revise any issues. They provided no corrections in 3 years. In her deposition, she stated I was her only accident as a driver. My lawyer found 4 other cases. They had hired a medical expert, the guy who racked up all her costs with steroidal injections, who admitted he might have overcharged her as he didn't know local prices. He also stated he might have recommended treatments she didn't need as he has to rely on what she tells him, and he didn't have a baseline to judge from. So prosecution is on the back foot and decides to try and use evidence that was not admitted to court, my phone records. Judge decided I don't have to prove my innocence, so they weren't necessary. After being told to stop doing that, he decided to nickname me Mr. Sunshine for the rest of the trial, and try and make the case as being how I should be accountable for the sins of my generation. To the point, he might have called me a school shooter. Jury heads out, there's other lawyers in the room for a separate case trying to set up a time for their case. As that's done, they talk to my lawyer about how insane prosecuting is. This goes till the jury comes back. I need 3 of 12 jurors to be found in my favor. I got 11. I cannot describe the feeling if 4 years of a trial to hear the jury finds the following: on negligence, defendant 0, plaintiff 100. My lawyer had just hit 40 years in traffic defense, and apparently his only rear-end collision to be found 0 at fault. Story 131 paralegal here. We have a case where our client is suing because a home remodel was unfinished, but payment was still demanded by the contractor. The opposing party claims they completed the contract and payment was due. When this case was being heard, the opposing party gets irritated with our client about something and says, "Well, yeah, I would have finished it if you had paid me in full earlier." Without missing a beat, the judge responds, "So, you haven't finished it then?" We stopped for celebratory tacos after. Story 132. Had a file where the issue was that my clients who had been evicted had left an apartment in a terrible mess. They testified that this was not possible, as they had worked their asses off cleaning. Their building supervisor gets up and testifies that they generated the cleaning estimate in advance, before the eviction notice, and never updated it or checked if there was cleaning done after that. Case dismissed. Story 133. I was a witness to an assault. At the start of questioning me, the defendant's lawyer started with "they didn't do it," and by the end of it went to questions along the lines of "they did it because you were egging them on." He also kept asking me questions the court legal advisor told the court he wasn't allowed to ask me due to hearsay, so I refused to answer them. I'd be pretty ticked off if he was my lawyer. Story 134. This was a few years ago when I was a prosecutor. This particular case was a DUI. The defense attorney hired an expert who was a former DUI cop in our jurisdiction. She was a DRE, which stands for Drug Recognition Expert. A DRE may not be what you expect. They don't look at drugs and tell you what they are instead. They make observations based on the field sobriety and other tests and determine what substances, if any, are impairing an individual. They are scary good at telling you the drug category a person used. My strategy was twofold. First, I fought as hard as I could to keep her from being qualified as an expert. If I was successful, great. He now has no expert to undercut my officer. If I was unsuccessful, opposing counsel did a good job of bolstering her opinion. Also good for me because after his direct where she found very little wrong with the report and admitted that her opinion was of little value because she didn't observe the defendant that night, I went over all of the arresting officer's observations. I asked if he was honest. She said yes. So there is no reason to doubt he observed these things? Yes. If you observed X, would you have arresting for DUI? Yes. I asked this for every single observation and then asked if she would have arrested and testified against the defendant if she saw the same things. Yes. I basically used her to prove he was DUI. I had a rebuttal expert that I didn't even have to call because her testimony was so good for me. I ended up calling him anyway, but just for good measure. Then, in closing, opposing counsel does this rambling story about concentration camps and internment camps and government overreach. At one point, he used a racial and the Asian bailiff literally yelped. Story 135. This is coming so late, I'll doubt it'll be seen, but I'll pop in with my 2 cents anyway cause it's relevant. Not a lawyer, but married to a paralegal. So she deals with this quite a bit during the discovery phase. Her firm spends most of its time suing oil and gas companies for things like wrongful death or polluting someone's land, or my favorite of a gas company deciding to up and leave a property because the owner complained they were leaving heavy equipment on land that wasn't supposed to be used for heavy equipment. Then after leaving, tried to make the landowner pay to have the equipment removed, because since it was on their property and not the property they were leased, it was the landowner's responsibility. The gas company lost that one. It's not quite accidentally proving the case, so it might not count. But generally the firm she works for is suing multiple different companies because they all have some form of liability in it. Every single one will do absolutely everything they can to pin the blame on another one of the companies being sued. This can be anything from allowing people to go to depositions and saying we did everything they said to do, to sometimes having people come into depots and outright say how the other company ducked up, to many times giving absolute definitive proof that someone else ducked up. One of her earlier cases had 6 companies, with 6 separate insurance agencies all being sued, and every single one of them pulled that because every single one wanted everyone else to be the one blamed for the screw-up and not themselves. Some of them provided emails that showed that one of the companies outright ignored safety regulations and worker complaints about lax safety regs. This was super damning. Then the company that ignored safety regs? They provided the other half of the same email chain, showing that the company that provided those emails originally were totally fine, with the second company ignoring safety regs and complaints. So many of these oil and gas companies will trip over themselves in order to prove that they're not the bad guy in this scenario, that everyone proves that all of them are hugely culpable for it. In some respects, it's hilarious to watch, but in most, it's just really, really sad. Seeing up to 5 different companies all knowing that something horrible is bound to happen at a site and all of them washing their hands of it until someone gets killed is infuriating and tragic. Story 136. Not a legal case, but funny nonetheless. My brother moved into a new home, and within days, a neighbor came to him telling him he needed to cut down the trees in the backyard on his side or the fence since they were near power lines. This would have easily cost about $10,000 given the size of the trees and placement. My brother didn't have the money or desire to cut these down right away, and the neighbor ending up calling the town to complain. They brought out a rep from the town to determine if they were dangerous or okay to leave there. The inspector came out, determined that my brother's trees were okay with the exception of one small one. However, the neighbor had about 10 along this rear driveway fence that needed to be taken down. Fortunately, my brother's father-in-law owns a tree-cutting business and said he would just do it for free for him, and ended up getting the business from the neighbor, about $15,000 worth huge trees, In a tight space, surrounded by homes, I think it was weeks worth the work. Neighbor himself on that one. Story 137. Am no big city lawyer. But I did witness a little stupidity. I was waiting to pay a speeding ticket and possibly get it reduced. The first cases of the day were DUIs, 4 of them. All the guys were college-aged and all had lawyers. The first 3 got the same sentence, 6 months probation. The 4th guy was about to get the same, and then his lawyer spoke too soon. My client has learned his lesson. This is his second and last DUI. The judge responds, second? Then proceeded to throw the book at him. Story 138. I had one at a deposition. I was suing a municipality for false arrest. During the deposition of one of the police officers, I was trying to delve into what I thought was an inconsistency in the officer's story. He claimed he saw my client and immediately approached because he believed my client was about to participate in a drug deal. The problem was that he didn't know whether my client was the buyer or the seller, and searching someone's car was a phenomenal way to scare off a drug dealer. Catching my client with a wad of cash and no drugs wouldn't have been a big win for the municipality's finest. When I asked him why he chose to approach when he did, the officer pointed out that my client was parked illegally, and that gave him probable cause to search his car. This isn't really true, but my job isn't to argue with the guy. We went around in circles for a few minutes. I exercised my discretion. As a police officer, I have discretion to approach the vehicle, and so I did. Finally, the cop's attorney got frustrated and yelled, "I think he's made it abundantly clear that there was no basis for his exercise of discretion." I asked counsel, "Are you testifying?" The cop, thinking he was catching on to some brilliant hint, said, "Yeah, there was no basis for my exercise of discretion." Then he gave me a eating grin like he's just won the volley. Story 139. I was a defense lawyer in a mock trial for Law 12 in high school. It was a losing battle. My client was clearly aggressive, even standing and threatening the entire courtroom during the trial. But in a rash attempt to wrap things up early, the prosecutor presented a photograph of my client's car, left at the scene of the Crimea parking garage. After close examination of the evidence, we discovered that the photograph was a picture of a car of the same model, but in an outdoor parking lot, and the prosecutor was charged for submitting false evidence. Story 140. I was working for a partner at a small firm which primarily did insurance law. He was the defense lawyer trying to prove that plaintiff did not suffer serious injuries in a car accident. The plaintiff was alleged to have sustained severe permanent back injuries, which left him unable to walk and could not stand up straight. While the plaintiff was on the stand, the partner I worked for asked if he had his insurance card on him at the time, at which point the plaintiff effortlessly stood up and reached for his wallet in his back pocket. Once he took it out of his wallet, he looked up and realized he just gave away his whole case. Story 141. I'm a family lawyer. I had a case where my client's ex-husband was trying to terminate my client's parental rights on the basis that she abandoned the child. Child was 7, and my client had not visited the child in a little over a year. He wanted his new wife to be able to adopt the child and completely eliminate my client from the child's life. In order to prove abandonment, you have to show that for the past year, the parent did not make any significant attempt to see the child. Problem is, it is a defense if the other parent prevents or impedes the contact, and my client had attempted for over a year to see her child and kept getting denied by the father. Luckily, it was all well documented in emails, letters, cards, text messages, etc. Opposing counsel's closing argument began with, "Your Honor, there are only 2 inches of emails here in which mom is attempting to see the child." My closing argument began with, "Your Honor, there are 2 inches of emails here in which mom is attempting to see the child." It was a very satisfying win. Story 142. It is common that you just take a stance that you know is questionable at best. You would be surprised how often the opposing counsel confirms or fails to contest it. In general, people are not willing to lie to the judge's face. There are people who do it and not think twice about it. But it isn't the norm. For example, just yesterday there was a hearing in a case about employment law. I stated that a certain clause was applicable on the employment agreement. My client told me it was part of the verbal agreement, and it was plausible, but we had nothing to prove it. The opposing counsel stated that it was indeed applicable. It won the case for my client. Story 143. Not as such, but I did have a juvenile justice clinic opposing witness break down on the stand and admit she'd done the thing my client was accused of doing relatively minor, so no worries. I had deliberately been put in charge of cross-examining the girl because I am a small woman and I look much younger than I am, even today, especially then, at 24, when I looked about 14. I was not threatening or frightening, and I could get her to say things my taller, more forbidding-looking co-clinicians couldn't. Even though it was small potatoes compared to some of the other juvenile justice cases, which is a field that will break your heart. I did it for a semester, and it did, and I could never do it for a living. It still felt oddly theatrical, like it was straight out of Law and Order. I was waiting for the donk-donk noise. Story 144 lawyer here. I have had a lot of cases where opposition can't back up their stupid stories, but actually presenting evidence against themselves is a rare occasion. Unfair dismissal case. Client, big fast food chain. Hamburgers, etc. for all the right reasons. Terminated an employment contract with an employee who didn't show up at work. Employee claimed that she had called the employer saying that she cannot come, and she is so sick that she has called an ambulance for herself. Employer didn't hear from her for 5 days after that, and employee claimed she didn't have any credit left on her mobile to call and tell she is sick. Of course, employer didn't believe her bullshit because these excuses are more common than you think. Not notifying an employer about illness is a considerable breach that can justify the termination. Employee argued that she called about the ambulance and she couldn't after that because no call credit, and because of that she had a valid reason missing work and the dismissal was unfair. I said that you never called, you just sent a text message about calling an ambulance while showing employer's phone, and told her that most people are released from ER on the same day due to overreacting, presenting that there was no excuse for her missing work or not calling employer. Asked her about the ER documents. She of course didn't have anything to present and said family doctor has them. Okay, I asked why the 5-day wait until you called. She gave the same no credit reason and presented the court her phone records to prove that she had called and informed employer after 5 days on her first chance about the illness, thus making the dismissal unfair. Little did the tiny-brained girl know that with that she showed her call history from the day of the ambulance text message to employer to the day her calling in sick, and all 5 days between. It showed no call to 911. After the text message, when she supposedly didn't have any credit to call, she had called to half her friends on the same day and every day after that. Also, before notifying the employee, she had called her friends, etc. I didn't even get to argue my "why didn't you ask someone else's phone" or "why is your profile active on FB" or text messages are free theses that I had prepared, when the judge angrily shouted at the employee, "Why are you wasting court's time here?" Dismissed. Well, that one went well. Story 145. This will get buried and may not go along with the actual question, but it'll tell the story anyhow. 1980s. I was 18 years old with brand new, 1-month-old Yamaha Maxim 650 motorcycle. I was in town, going 35 miles per hour, and a lady pulls out in front of me. I hit the brakes and lay the bike down, but still hit her front fender and flew over the hood of her car. Ambulance comes and takes me to the hospital. Broken right wrist and broken right ankle. Policeman in emergency room is filling out his report and gives me 2 tickets. 1 ticket for no motorcycle license driving and 1 ticket for no insurance. Court date in 4 weeks. Just so happens the court date and my follow-up doctor appointment were on the same day. So I go to the doctor and we wait and wait. Finally, my mom goes to a payphone and calls the courthouse in the other county and lets them know I will be late, 'cause doctor appointment. Doctor checked the x-rays and says 3 more weeks in a cast on both limbs. So the nurses tear off my casts and put new ones on me, right arm and right leg from the knee down, so I am still on crutches. We get to the courthouse and open them big doors, and this place is packed with people, nowhere to sit. I guess they were all there for traffic violations, like me. Mom says, "Wait here." By the rear door, she walks down the side aisle and gets to someone. IDK who? The clerk? Judge looks at me and says, "Temet Noshi, approach the bench." So I hobble crutch my way up the center aisle. All eyes are on me, my crutches and my 2 casts. Finally make it to the front. Judge says, "Temet Noshi, you have 2 tickets here, 1 for driving without a motorcycle license and 1 for no motorcycle insurance. How do you plead?" I say, "Guilty, sir." Judge says, "Temet Noshi, I believe you have been punished enough. Case dismissed." I said, "Thank you, sir," and hobbled my out of there. Story 146. I was on a jury once. The idiot defense lawyer explained to the judge right in front of us that the witness that was going to prove the defendant's good character was not present because he had died a few days before. The defendant was in trouble because of how aggressive he had been in the middle of the night when the police had arrived for a noise complaint. The witness had died because he started a shootout with the police months later while robbing a store. If the lawyer had told the judge privately, we would have never known what kind of crazy people this guy ran around with. If anyone thinks we as a jury should not have held this against the defendant, you are probably right, but you should never be a lawyer. Story 147 TW Assault. I did work for one case where the defense had no clue how to defend a convicted rapist because he was guilty as without lying and making up about another rape trial. So we tried to call a witness who would say that she had not seen a rape take place. Well, she did say that, but she also said that a large black man in a mask and a gun had told her to sit down and keep quiet as he ran from the scene where her sister-in-law had been sitting on the ground, shaking and crying. The victim had testified prior that she had been raped by two large black masked men who had taken turns holding a gun to her while the other raped her. Jury took about an hour to convict. We asked them afterwards about our witness, and they felt that it had sealed the deal for them, even more than the DNA evidence. Honestly, I sleep better because we lost that one. Not a lawyer, but used to flat with a guy who used to be a cop. His story involved a guy accused of burglary and the trial. My friend got up to the witness box with his uniform on and stated that he'd lifted and identified the fingerprints of the accused. The accused shouted out, "He can't have, Your Honor." I was wearing these gloves at the time while showing the fingerless gloves he was wearing. Story 148 ex-wife sues me for $400,000 plus a year of support. After I paid for grad school and 3 years of med school, and after the divorce was final and agreed upon, she basically wants half the condo I bought and was living in, claiming she had lived there for the better part of 4 years. Except she could not state the address of the condo when asked. And finally glances at an old check on mine on their table and states that address. Well, you can have the property at that address. It's your parents' house, where I lived putting you through school. Her lawyer exited the court and the case. Story 149. Not a lawyer, but a sticking it to them story. A long time ago, 17-year-old me was driving down our small-town road to school. After I park my car and get ready to get out, a cop pulls behind me in the school parking lot and turns on his lights. He proceeds to give me a speeding ticket. See, the road I was on passes by a middle school, and evidently the school zone lights were on, and therefore I was speeding. I knew it was bullshit and the lights weren't on, but I was 17. I wasn't going to argue with the officer. But what I did do was figure out how to get the light schedule for the middle school and went to court to fight the ticket. The officer was there. The judge asked me to step up and explain what happened. I did, and then proceeded to explain that the school zone wasn't in effect, and I had the middle school's light schedule as evidence. The judge took that and compared it to the timestamp on the ticket. He agreed that I shouldn't have been ticketed as violating the school zone, but nonetheless I was speeding, but the fine would be standard. I objected and said that if the officer was able to lie about the initial ticket, then it's not a jump to conclusion to assume he would lie that I was speeding as well. I asked for it to be thrown out. The judge laughed and said he didn't agree with my assessment of lying but threw out my ticket. Story 150. Not opposing counsel, but the plaintiff did ruin his own case, was defending a prison and prison guards against a rape allegation. Plaintiff alleged that in the middle of the night, prison guards and other inmates took turns raping and sodomizing him. He said about 20 guys took turns. Sounded a little far-fetched, and for once we had video of his cell at the time he alleged the rape occurred. I pull up the video. Plaintiff is alone in his locked cell. No one around him. He is himself up with one of the legs of his bed and screaming. Other prisoners are walking by his cell. Some watch, some laugh, some run away. Once a prison guard sees what's going on, they go in with gear and calm him down with a 2-second burst of pepper spray to the face and drag him out. To this day, I am convinced he actually thought he was raped by 20 dudes. Story 151. Not a lawyer, but I represented myself in open court against the DA for a reckless overtaking charge. I passed a car that was going 20 in miles per hour zone. The oncoming traffic about a half mile down the road was a local police officer. He flipped on his sirens and wrote me up for unsafe overtaking because there was oncoming traffic visible. I researched the exact wording of the law I was cited under. I Google mapped the area, made measurements of the distances involved, filed for discovery to get a copy of the police officer's dash cam, which showed the overtake maneuver I performed. The DA went first and questioned the police officer. I was able to cross-examine and ask leading questions that in the end, his own testimony proved I never violated the law as written. After I had him give a recount of the events and probed on him to estimate distances, speeds, and times while showing the dashcam video, I then brought out printed copies of the exact law, which gave minimum distances of oncoming traffic for the safe pass. His estimate of distance was probably 5 times the distance allowed. We agreed that I didn't speed to make the pass. And on stand, he agreed I did not violate the law, just that he felt it was unsafe. The local DA fought me in court and tried to object and use the court rules against me. Judge threw out some of my questions and evidence, but in the end, I still got the officer to admit I didn't violate the law he cited me for. Judge ruled in my favor, and the case was dismissed with no record or costs to me. The DA outside the room came up to me and said, "Good job," and walked away. I am not a lawyer, but in my recent case, the opposing counsel provided documents in discovery that were not known to our side and proved our case for use. Background: I live in a HOA community in which owners would rent their properties during the high winter season to snowbirds. This one guy became president and didn't like it, so he and a couple other board members went to the community developer who held the rights to all rentals, but had no interest in that, so he did not enforce for many years. The board members traded something to him, which I will not mention, as it has no relevance for the rights to the rentals. The group I was a part of sued a few years later, as we knew this went down in a shady manner and we had other evidence to prove our case. The thing is, the meeting the board members had with the developer was illegal, in the sense it violated the governing documents of the community. Only thing was, we could not prove the meeting actually even happened. A couple years into trying to get the case into court and during discovery, the opposing counsel gave us documents that included meeting minutes from our own board meetings. One of these meeting minutes detailed the meeting and proved the actions of the board were beyond their powers and illegal. This, in the end, did them in. Story 152. I am not a lawyer, but was in the middle of my mom's divorce to my stepdad. They were both very stubborn people. My mom decided to sue my stepdad for alimony. At the time, I was doing their taxes, as their taxes were not complicated. The prior year, my mother made slightly more money than my stepdad because of overtime. I advised her not to pursue alimony because of this. She is stubborn and went on a self-righteous rant about how she put so much into the relationship and deserves to live comfortably. She lost the alimony. Stepdad countersued and won. Stepdad took one alimony payment and dropped it a month later. To this day, approximately 10 years later, my mom still calls him in with the "what kind of man does that?" attitude, all for him countersuing her for alimony. Story 153. I'm not a lawyer, but I was one involved in an accident when on a rainy night, someone cut in front of me, forcing me to swerve into another vehicle. The driver who caused the accident drove off without ever realizing what they had done. The policeman showed up, spoke to the driver of the vehicle I hit, then issued me a citation for failure to slow down to avoid an accident. He didn't ask me what happened. He didn't give me an opportunity to explain. He just wrote the ticket, fine, and points off my license. So I went to court without representation, hoping to be able to explain myself and possibly get a reduced fine, etc. The judge asked guilty or innocent. I pleaded not guilty with an explanation. He laughed and said I couldn't do that, but apparently understood that I just wanted to tell my side of the story and took pity on me. He asked the police officer if he witnessed the accident. When the officer said no, the judge said, "Well then, how do you know he didn't slow so to avoid it?" Case dismissed. Story 154. Really simplified version of a case that took 10 years to wind through the court. We had a client who was charged on the federal level with murder for hire. The government claimed he was selling bootleg cigarettes in NYC and had his rival killed. Well, come trial, the killers get up on the stand and admit to the AUSA that they didn't know the defendant, he didn't pay them, and guy they killed was a rival selling bootleg cigarettes in their housing project. Case went south for the government quick. Story 155. I'm not related to mine, but I have researched it because it pertains to my lifestyle, sequence of events. There was a gent who was driving with something like 9 pounds of weed in his trunk. He was smoking a joint going down a main highway. A cop sees him, can clearly see that he is smoking a joint, flashes the cherries, Guy throws the joint out. Cop smells pot. Calls for a drug dog. Drug dog signals positive on the trunk. Open trunk. Find the drugs. Dudes gets arrested. In court. The officer who pulled over the guy was testifying. The defense attorney was questioning him. He was giving him the gears about how was he certain that there was pot in the car. What he was trying to figure out was his probable cause to search the vehicle. So he asked the cop if he could see any drug paraphernalia. The cop said no. The guy presumably had just rolled a joint for the highway and sparked it. The cop then went on his rant about how many search and seizures he has been a part of. He even went to many grow-up busts. He was saying how marijuana has a very distinct odor that was very recognizable, and when he would come home from raids, his wife could smell the weed and comment about it. Now that last part is crucial, the quick-witted defense attorney replied with, "So you are saying that your wife could smell marijuana when it wasn't present?" The cop had to reply, "Yes." Probable cause went out the window. Set a precedent in my province. Everything got thrown out. Guy went home. The cop hung himself pontificating about his bona fides, and I love it. Story 156. Not a lawyer. Heard this from a friend years ago who was observing a trial. Domestic violence case, and she is up on the stand recounting how he was beating on her. He claims she was hitting him. Officer's statement confirms she looked roughed up and bleeding. He looked roughed up too. During her testimony, she says how he forces her out of the house and locks her out. His lawyer questions how she got back in as the police found them both inside. She calmly explains how she took a chair off the porch and threw it through the front window, quickly followed by her jumping through the window to come at him for round two. Her lawyer buried his head in his hands and accepted the fate. Story 157 IANAL, but dated a girl who worked for the police as a chemist and regularly testified. She was called to testify in support of an analysis she did on some ashes, which were assumed to have been marijuana, taken from an old-fashioned wooden pipe. The cop claimed to have smelled marijuana and arrested the defendant based on that. Defendant had a prior for possession. The prosecution put her on the stand, asked her what she concluded, and she replied that the ashes were composed of unknown organic matter and did not test positive for marijuana, as it said in her report. The prosecution hadn't read it. Defense moved to dismiss. Judge dismissed. Prosecutor got in hot water with the judge. Prosecutor was incredibly pissed at my ex. Story 158. My client got sued for unpaid credit card that wasn't his. In discovery, I asked for all statements. Plaintiff's attorney produced documents with social security number blacked out, citing privacy concerns. They sent me the original blacked out statement done with a Sharpie. You can read print through a Sharpie. Took documents to court with huge Sherlock Holmes-style magnifying glass and let judge use it. The print behind Sharpie clearly showed SSN that wasn't my client's. Opposing counsel himself and plaintiff paid all my client's attorney's fees and costs. Thing is that it's super easy to effectively use Sharpie like they were trying. Blackout text with Sharpie, run through photocopier, and obfuscation is done. Just don't use the copy with the original Sharpie work. Story 159. Had a case where the plaintiff claimed she signed a home loan promissory note with a different interest rate than the official version we had. The original rate was something like 6.2 for an interest-only period before readjustment, but she alleged that she agreed to a rate of 1.7, which was absurd for a home loan in the U.S., and attached an altered version of the note to her claim in an attempt to make the rate a factual issue. When we looked through the entire copy, it was obvious that it was a bad Photoshop of an OCR of the original note, because all of the number 2s had been replaced with a 7, leading to ridiculous results. The loan was originated on March 78, 7005. Payments commence on May 1st, 7005. Even the original loan amount was changed from the 200K range to 700K, meaning she would owe more than double. Her attorney was apparently in the downward spiral of substance abuse, so when we called to inform him of the issue, he said something like, "Well, let the judge decide." Everyone hates banks. The judge did decide, in our favor, and was glad we didn't try to seek sanctions from the lady or attorney. Bonus fact: attorney was disbarred shortly after this in part for making up claims and signing things for clients who were unaware of what he was doing. Because we had already won, we let it die without getting to the bottom of whether ours was one of those. Don't do drugs, kids. Story 160. Am late to this game, but have a strange version of this. Opposing counsel once brought in a witness during an evidentiary hearing before a magistrate judge to authenticate some documents they were introducing into evidence as proof of payment. Witness proceeds to vociferously state that the documents were not what counsel stated they were, and were, in fact, not proof of payment. The documents were introduced as evidence that there was a database of payments that should be made. Our case was predicated on the fact that the payments were never made, and it's actually impossible to prove that someone didn't do something. The next day, magistrate judge tried to refer to them as proof of payment. I politely reminded the judge that the witness the day before had not actually authenticated the documents as such, and had merely showed that it was a list of payments they should have made. This leads to a 1.5-hour recess as the magistrate judge and clerk try to figure out what I'm talking about and go back over the transcript presumably. I wasn't in the chambers at the time. Magistrate judge comes back, agrees with me, then says they're proof of payment anyway, because they're the best proof of payment he has, even though a witness had told him that the documents weren't proof of payment. As the hearing continues, because these documents now constitute prima facie proof of payment, we are tasked with providing records that prove that payment did not occur again, an impossibility. As you might imagine, this did not go so well. Anyway, we've actually been winning this case overall, funnily enough, but that was an incredibly aggravating lesson in the power of a magistrate judge. Story 161 IANAL, but I have a story that somewhat fits this bill. A while back, I was contacted by the FBI of all things. As an aside, that's a shocker. When I got the call, "Hi, I'm Agent Joe Blow," not his real name from the FBI, I was like, haha, go off with your friends from Windows Tech Support and the Disabled Veteran Police Llamas Fund. I let it go on a bit, and the gist of it was that he wanted to ask me some questions about my urologist. I had no idea what it was about, but I said I didn't speak to LEOs over the phone, so if they wanted to interview me, I'd have to do it at their office so I could see their identification. Otherwise, they could have been anybody, including former police llamas. So that's how I got to go to the FBI office, which they apparently had one of near my hometown. It was just one end of one floor of a regular old office building, which was disappointing. I was expecting something like the opening of Get Smart. Google it on YouTube, youngsters. I'm old. After I signed in on a sadly normal yellow legal pad, they escorted me to an office that had stacks and stacks of medical records jackets. Agent Joe Blow, not his real name, came in and dug around until he found mine. He went through it page by page to confirm that I had all the procedures done that my insurance had been billed for. There was one I wasn't sure of, so he made note of it and got up to go check with someone. He told me not to leave the room because the rest of the office was a secure area and he had to me through it. About an hour later, he came back and apologized profusely. Something urgent had come up and the whole office had been involved. He took my statement as something like witness is unsure whether or not procedure X was performed on date Y, and that was the end of it. Or so I thought. But when I was later contacted by the defense attorney, he was confused about why I had driven all the way to the FBI office. I explained that I wouldn't want to talk to supposed cops over the phone and such. How I'd signed in, how they showed me my medical records, how I'd been left in the room alone while he went off to whatever the urgent thing had been, and wait, what? Defense said he quizzed me for about an hour. How many records were there? How were they arranged? Stacks on floor? Stacks on desks? Alphabetized? Yada yada. I recalled the best I could try to be accurate. Eventually, he was satisfied and he let me hang up. I got a call about a month later from my urologist. The judge in the case had been furious about the chain of custody issue. Apparently, you're not allowed to leave potential witnesses alone for an hour with the paperwork that's your primary evidence. He hadn't been able to get all charges thrown out, but the majority of them were tossed, and he was able to plead to something trivial that didn't cost him his freedom or his medical license. He got a slap on the wrist fine and had to provide some kind of annual auditing for the next few years. I have no idea if he was really fake billing, but that FBI agent basically screwed up his case simply by leaving me alone with a bunch of medical records. Note: it confused me at first too, so I should explain that the reason the FBI was investigating was because some of the alleged fake bills were to Medicare/Medicaid. At least that's what I was told. TLDR. Got a call from the FBI, yikes, and had to go to their local office to be interviewed in an insurance billing fraud case. While there, was left alone for over an hour in a room full of medical record jackets, including mine, which were the primary evidence against the defendant. The defense raised a chain of custody stink that was enough to help the doc beat most of the charges and get off with a slap on the wrist. Story 162. Not exactly on point, but anyway. I was representing a man who had previously been convicted of soliciting a minor online for basically the exact premise of To Catch a Predator. His sentence was almost up, and the state was trying to argue that he should be classified as a violent predator, which, even though his sentence of his conviction was about to expire, would require him to remain in the custody of the Department of Mental Health until such time as he was no longer deemed a violent predator. He would have been able to petition the court once every year, I think, for a new determination. The AG's office sent out their notice that my guy was going to be evaluated by their forensic psychiatrist. A month or so later, I get notice that the evaluation is complete and they were going to forward it to me as soon as they get it. Fearing the worst, I'm already preparing my motion for the state to advance funds to me to hire my client's own psychiatrist guaranteed under the statute when I get an email from the AG. It's their own evaluation, and the psychiatrist found in no uncertain terms that my guy is not an SVP and should be released upon expiration of his sentence. I call the AG, tell him I'm going to file a motion for summary judgment based on the evaluation, or he can just agree to dismiss the whole thing. He tells me, well, our policy is I can't consent to dismissal, but I won't oppose it in court. Okay, whatever. So I file my motion, we have a hearing where I just introduce the AG's report into evidence and make a brief argument. The judge asks the AG for their response, and he says he has nothing to add. Case dismissed without a testimonial hearing or trial due to the state's own expert saying my guy is not a violent predator. He got out upon expiration of his sentence, and apparently his wife welcomed him back with open arms. Story 163 lawyer here. Was representing a guy pro bono on a different matter. Dude tells me his ex is trying to get him in trouble with the police for hooking up with ex's daughter when she was underage, like 14-ish, and the police are asking him to come in and talk to them the next morning. I tell him I'm not a criminal lawyer, don't represent him as to that, etc., but that every crim lawyer I know would tell him not to talk to the police and that he should have a lawyer for that. He kinda yeahs me. 2 days later, he calls to tell me he talked to the police. And it was all good because they were really nice and understood that anything that happened with him and ex's daughter was totally consensual. I wished him well and gratefully passed the matter on because I was leaving the firm soon. Not exactly what was asked, but figured it was close enough for a thread, otherwise mostly filled with fake lawyers telling fake stories. Story 164 IAAL. But this one is a pro SE plaintiff, not an opposing lawyer. Client was running a program that was funded with federal dollars and subject to federal regs as a result. Employee violated the regs, so we had to let her go. She filed a pro C complaint of discrimination, checked off every box she could find: race, age, gender, etc. It was pretty clear that she had just checked off all the boxes for the sake of checking off all the boxes. After a motion to dismiss, the only claim that survived was for age discrimination. So I took her dep to see what evidence she had of age discrimination. Naturally, I wasn't expecting much. At dep, she testified that the office she worked in ran as an old boys club, that her boss stole her ideas and wouldn't give her credit, that she'd gotten passed over for a promotion in favor of a white male, etc. All fairly standard stuff, except none of it concerning age. She was pretty whipped up about how unfairly she'd been treated, so I asked her, "Do you think being any younger would have made a difference in getting that promotion you wanted?" She slammed her fist down on the table. "Nope," she declared. "Do you think being any younger would have made a difference in getting that raise you didn't get?" Another pound of the first with a nope. Case over. Story 165. I represented a grandmother in a guardianship trial. Her daughter, the kid's mother, died of cancer and had sole custody of her children before she died. The father wanted to take full custody of his children and take them away from where they lived their entire lives. Our argument was that he was completely unstable, made poor life choices, and it was the best interest for them to stay with grandma. Prior to trial, he kept emailing me all of these conspiracy theories, mostly about how Fukushima was poisoning the ocean and it was going to get to the West Coast, and everyone needed to get out immediately. Needless to say, I just attached every one of his emails of ranting as exhibits. The best part of the trial was while he was testifying, more just emotional ranting. Finally, the judge asked, "Sir, have you been drinking today?" "I had a few beers during the lunch break. Why did you think that was a good idea?" Grandma kept custody, and the kids are now adults and doing well. Story 166 IANAL. But I was in court waiting to give testimony in a preliminary hearing for an unrelated case. It was a DUI case. The prosecutor made a point of describing how the weather and road conditions made this case important to proceed with prosecution. According to the arresting officer, it was a dark and stormy night. The car hadn't pulled over far enough for him to approach on the driver's side, which probably pissed him off. So he had to approach from the passenger side. The defendant only opened the window a small amount. We'd hear later that it was because it was raining so hard, not just to off the officer. The officer then claimed he could smell a strong odor of alcohol on the defendant's breath. He asked for the driver to do a field sobriety test, which the driver refused. Again, we'd hear later that it was because it was raining out and he didn't want to get soaked. Not just to off the cop, but the cop got pissed off anyway and arrested him. Breathalyzer came back 0 alcohol. Blood test came back negative, but cop said he was still agitated and obviously under the influence of some substance. Defendant took the stand, explained why he didn't roll the window down or get out. Judge heard the testimony and said he'd give a proceed dismissal decision the next day. After my bit was over on the unrelated case, I noticed the defendant's lawyer in the courtroom antechamber. So I walked up to him and said something on the order of, "I was listening to your case, something made me curious. How was the cop able to smell a strong odor of alcohol on your client's breath all the way over from the passenger side, through a window rolled down just 3 inches, on a night where it was so rainy and windy that the arresting officer made a point about it being extra dangerous to be driving under the influence?" The lawyer thought about it for a minute, then smiled and thanked me. The last I saw of them as I was leaving was him going back into the courtroom and leaning over to talk to the clerk, presumably to get the judge's attention. TLDR was in court to testify on a case. Saw another dude's DUI preliminary hearing. Cop lied on the stand. Prosecutor asked him exactly the questions required to prove cop was lying.